Welcome to the Foul Play YouTube channel.
Greetings, everyone. Hope everyone's doing well today. Welcome to Open Mic. I think we're up to number 72. Today, we're going to be talking. Can everybody hear me? Yeah, you should be able to hear me. Anyway, today we're going to be talking about the last Colburn hearing on July 7th. And we got a couple of documents to go through to get current with that. And then at the end of that, if there's time, the Colburn hearing is a little bit less than an hour, and we'll be pausing a few times to talk about some of the things that the lawyers say and the judge says. This meeting wasn't as volatile as the last hearing, but the judge was still, you could tell he was irritated. Of course, we know that Colburn's deposition is coming up on July 21st. We'll get more in depth and discuss that as to what's coming and what this actual hearing was about. But first, I do want to welcome everyone. Let's see who we got in the chat here. I want to thank Jinx and Alice and Rhonda for joining me here on in Discord for the discussion. I see the lovely Dark Side Supermod. There's Jazz Naz, Andy B. Guys, all month watch Andy B closely because it's late for him. Kidding. Pete Moss, hello. Who else we got? Dassey, Sherry. There's Sherilyn Pantillo. Hey, thanks for coming. Who else? There's CT and Fangirl, neighbor. She doesn't look far away. There's Jennifer Manning. Who else we got? There's JD. Welcome, Jay. I'm trying to go through here. There's Stacy Seabrook. Thanks for coming, Stacy. Always awesome to see you, sir. I missed anyone? Alice, Rhonda, Jinxie? You guys see anybody I've missed? I'm trying to see all the names here through the chat, but that's pretty much all I've seen so far.
Shiva Smokey, Paul Ward, Pete Moss.
Yes, I got Peace. I didn't see the others. Hello. Yep, okay. Thank you.
JD, Ronald Cass, PTM. Yeah.
I
think you got them all.
Well, you know, this, as everyone knows, this weekend was a rally in the UK and rally in Manitowoc. A lot of
Sapper Pop, we forgot Big Daddy. Jack said.
Big Daddy.
Sapper Pop said we forgot Big Daddy.
Hey, Sapper.
Whose Big Daddy is he?
Yeah. Hey, you're certainly welcome to join us on Discord if you want, Sapper. I'm sure you've got plenty to say about this damn judge, and I think you can have a lot to say if we have time to play this video to end. It's about a 10-minute video. It's quite disturbing. It's completely unrelated to making murder. It's a different case altogether. But I posted it in our Discord, and it is quite maddening. Anyway, so with rallies this weekend in the UK and in Manitowoc, and people have routed. Oh, I think Jinx just got home recently. Rhonda got home late last night. So let's kind of go down the list here and let everybody say hello. And if they want to talk about the rally briefly and their experiences, then let's just do it. Let's just go ahead and do that right now. So Alice, how are you?
Hi everyone and chat. Thanks for joining us tonight. Yeah, I'm doing good, Jack. I've got a dog that's bugging me. He's wanting it for a pee, so I'll just say a quick hello. Hi everyone in chat, and thanks for joining us tonight.
Awesome. Jinxie, how was rally? How did the rally treat you?
Everybody's on mute.
Yep. Well, you go ahead, Rhonda. You went to the rally. How did it go?
I did go to rally. It was fabulous. It was very inspiring, very some places that we went to, we kind of did our own little tour of different areas, different things that we wanted to see that we missed last year, Cherie and I,
Did you all find
because of
that
Jan.
beach that you all were looking for? I know that
I did
Cherie.
find the beach. I tried to post the pictures. Now that I'm home and I have my own Wi-Fi, and I'll go ahead and send you the pictures that I took. But we found the beach, and I think I know we walked like a good mile and a half probably, and we still weren't there. And I was done. I was beat, and so I we were able to get a couple of pictures, and I have one that we're very confident that based on the pictures in the website and on map and everything, pretty sure it was the area that where the 1985 assault took place. And it was just a strange, it's just some of those places are just very strange, heavy, kind of eerie feelings, I guess, because we went again to Cuss Road, and this time we were able to get to the quarry, and just well, we went to the spot. I'm 95% certain that we were able to hike into the spot where the one call talks about the guy that was geocaching and saw
Oh,
the
the
bloody
blood,
tree root.
the blood all over the
Yeah,
trees.
yeah,
Oh, damn.
yeah.
Yeah.
So I'm pretty sure that we got to that spot, and I'll post picture. Or well, Cherie did some video and pictures. I was leading the little the little adventure, so she was doing video and taking some pictures. So I'll have her post those when she gets home today from her thing. But
Nice.
anyway, so just some really, we went back to the cemetery and took some pictures of Teresa's grave, and I had some thoughts that probably have been discussed already a million times, and I've just never been a part of the discussion or whatever. But I have some thoughts about the grave that I wanted to kind of pose to the group at some point whenever we get a chance. And hey, BW, it's great to see you, Haggis. How are you doing? Um, and so anyway, it was just really, really amazing going to the rallies. Oh, we have pictures. I have lots of pictures of the Jinx. Jinx will be able to relate to this. We drove around for, so after the rally on Friday in front of the Manitowoc courthouse, we one of the supporters took us all to lunch, and so Pete had recommended a place in Two Rivers. So we left Manitowoc and drove to this restaurant in Two Rivers to have lunch. And on the way back, we were going to look for the billboards, the changing billboard with
Oh,
that
with
that
Brendan.
talks. Yeah, with Brendan, and then there's also the $175,000 reward billboard that it switches to. So we drove around the directions that we were given by another supporter that had already seen it. Drove around. Some of us walked. We looked every which way we could for this address that was 25th in Washington. And if you stood in the parking lot of the Walgreens drugstore, you could see it from that parking lot. So we were driving, and anyway, so we're all following each other around this whole place. And sweet Rhonda SD from the UK was at some point she got in the lead, and I was like, "What the hell is she doing leading us? It doesn't even know America, poor
Oh,
thing." But anyway, we got into this one place, and everybody just stopped in the road. And one of the supporters' husbands walked back and told us on our car, "It's in Manitowoc." We were in Wisconsin. We were in
oh
Two Rivers.
no.
But it was so strange because they had a 25th in Washington, and they had a Walgreens drugstore right there. And I mean, it was just like, what are the odds? Anyway, we ended up finding it. And I know that Becca was live from there for quite a while, and we got some really good pictures and video of the billboards and stuff. So it was amazing. It was
maybe,
really, really it was fabulous. And
well, well, maybe we can have once we get the photos, we can get them in an album, and then we can maybe do an open mic, and you guys can talk about your experiences about what you saw.
yeah, yeah, I think that's a great idea because I mean, I know that mine and Cherie's and her husband's experiences are going to be different from
Sure.
Jinx and Becca and Linda and every and Rhonda SD. And oh my goodness, there were so many people there that we got to meet that it was just it was
Yeah.
fabulous.
Yeah, it looked like there were quite a bit more people this year. Quite a bit more people this year than there were last year.
I think so. I didn't get to go to yesterday's rally. Jinx will have to tell you about that because we were getting ready to fly back home. But it looked like they had a really good turnout yesterday because it was warmer and sunnier. And when the day we were in front of the courthouse, it was kind of drizzly and cold and yucky and whatever. But we still had a good turnout for that. So it was great. My experience was fabulous, and I can't wait to do it again next year already. So I need a good week or so to recover though, because it's hard on my body.
Maybe here in the next week we can get those photos on an album. We'll just open up a mic and just talk about it.
Cherie and I will get our photos and videos to use from our phones. My pictures of Xander Road, we went on 2 different excursions to Xander Road.
Good.
And on Xander Road is the address that's on the paper that's in the trailer that they make a big deal about. But anyway, we drove out there and finally we found the right place, but it was all overgrown, like the farm that was there and the house, the overgrown house that was there that with the address, all gone. It was all cornfield. I told Cherie I felt like we were in a episode of the X-Files because it was just gone.
That is crazy.
Yeah. We have pictures of the turnaround. So yeah, anyway, I could talk forever. Let's get on with the subject though and hear Jinx's experience.
Well, I see Carol's joined us before Jinx. Thanks for joining us, Carol. How are you?
Carol and Sapper.
Yep. Are you here, Carol? If you're having trouble finding her, she's unmuted. Well, let's give her a minute. Jinxie, are you back? How was your experience? There she is.
I am back from rally. Got back around 1:30 this afternoon. Hi guys, thanks for coming to the live. I had a great experience. I got to go into the courthouse and into the sheriff's department on Friday. Picked up some records from the sheriff's department. I was just thinking, because I went into the courthouse, where did I put those names? Because I wrote down the 12 juror names from the first case.
That was Manitowoc County Courthouse, right?
Manitowoc County Courthouse and Manitowoc Sheriff's Department. I didn't get to make it to the other 2 rallies, but I did make it to the Manitowoc ones. I'm drained. I'm surprised I still have a voice, actually, because all that yelling, usually I lose it.
Well, good.
But yeah, it was good experience. So when you guys have a live and stuff, I'll get on and share more, I guess. I still have to look at those records, so I'll get on that sooner than later, I hope.
Absolutely.
Also,
cool.
I'll share pictures and video of, sorry, I didn't mean to cut you off, but before I forget, I'll share pictures and video of Fox Lake Correctional Facility where Stephen is. And I was approached by law enforcement, 2 captains from inside the prison, and then went back out to Oshkosh. I spent only about maybe 3 or 4 minutes out there because last year I got hassled, and because of what the situation that we were in, I didn't want to stand up for I didn't want to fight for my First Amendment right there in Oshkosh last year. But anyway, I have some really nice video of those 2 prisons as well.
They don't want you taking videos at the prison for a reason.
Right.
Because they don't want you to be showing all the doors, the windows, and all that stuff in case somebody wants to break them out.
Oh yeah, I know. I've heard their spiel, and it was, because technically it's not illegal. Technically it's public property, and you can, but they do tell you, well, it's secure facilities and that's true too. I understand that, but after I spoke to the 2 captains at Fox Lake, they were very, very respectful, and I was just as respectful back. And I did play dumb a little bit just so I could be like, oh, I'm not supposed to be recording here. Oh, I'm sorry, so I did do an audit on the a First Amendment audit on the Calumet County Courthouse. We were in there for quite a while, but there's bad news about that video that I won't be able to share because I ran out of space, I guess, on my phone and it didn't record it. So it was interesting, but it was a wasted hour of time that I was really disappointed in. And then
Oh,
I went into to the Manitowoc County Courthouse to do an audit, but we ended up going to lunch instead, so I didn't get a chance to do the audit there. But I'll get them. I'll get the places next time.
sweet. All righty.
Anyway,
Well, Sapper Cop, how you doing, sir?
Well, I'm currently in the middle of my second round with COVID, so we'll see how that goes.
Oh, no.
Damn, is it bad like last time?
Actually, no. This is like day 4 now, and the worst I've had is just slight headache and stuffy nose. So hopefully that's the way it stays.
Yeah, you sound like you got a little stuffy nose, but not bad. So.
Yeah, that's about the worst it's been. Is just a pretty bad stuffy nose, but other than that, that's it. No fever. No. I had body aches the first day, but that's been gone. So.
Oh, interesting.
I don't know why. I don't know why COVID wanted to come back. I beat its ass first time.
Wanted round 2 and 3, I guess. And I feel pretty fortunate. I tried to stay isolated because I got other health issues. So I've tried to, and my family's been really good. So anyway, I hope you recover quickly there, Sapper, and doesn't really do anything else except
just quickly before we get started, Jack.
Yeah.
BW Haggis has just became one of our newest members. 2-month membership. So congratulations, Haggis. Thanks very much. We very much appreciate it.
Very much. See, he's I thought looked like it was an obsessed member too. So. Woo.
By the way, Carol says hi, and she has no mic on her desktop, but she is here and listening.
Oh, okay. Well, that's cool. Well, hope you can get that rectified, and you're always welcome to come and join and be a part of the conversation. So, wanted to give a shout out to Dr. Silkman, and he's under the weather and has been working through his own issues, and hopefully that can get worked out sooner rather than later. But yeah, we wish him well. BB as well. Heard from BB in quite some time, but hopefully she's doing okay. So wishing both of them well. So, alrighty.
I went and saw a specialist, by the way.
Did she?
Recently, so she's looking to have some pretty major surgery, but they got to get her healthy enough first. So everyone pray for BB.
Yeah, that one surgery she's talking about, it is pretty major, but if they can do it probably would help significantly. So, alrighty, all right, let's get flipped over here and let's talk about. I'm going to actually do the first document, which is document 255. This is leading in. I'm switching gears on you guys, going into the hearing. As we know, Netflix. This last roundabout was with Netflix wanting greasebox notes and material that he used to write his 2 books before he was still an ADA, and this is before he became a lawyer for Andy Colburn. And the justification for that is because they have access to that material, the defense doesn't, which is Netflix and so forth. So they kind of have every right. The judge was very good in explaining using the sword and they can't use a sword and shield approach to not turn that information over. So, as I understand it, he did turn over whatever he had to the Netflix lawyers. So that subject seems to be passed. The next thing is Andrew Colburn's deposition, which comes up on July 21st. Standard deposition is 7 hours, basically a day. Because of the complexity of the case, and the number of lawyers, and then we can't fail to mention the third party connection with Brenda Schuler convicting a murderer, and possibly even Sean Reck. That's he's the executive producer of Convicting a Murderer. All that adds just another wrinkle to an already really screwy case and complicated case. So they felt like they needed another day. And as you'll hear as we go through the hearing, you'll hear the Judge Ludwig. I don't think I'm not revealing anything that everybody doesn't know. We'll hear the interesting things about the hearing. But I think Judge Ludwig was pretty irritated, but and we'll get more into that as we play the audio. But this is what this is about. They want a second day, and of course, Colburn's lawyers are like, no, they're resisting that. So we'll go through that. Let me pull this document up here. I'm sitting here rambling. Let me pull this document up. Where we at here? Yep. Okay. Here we go. So this, there we go. This is document 255. And I think we'll see it. It's got a date of July 5th on down here at the bottom, but it's a couple pages. I'm going to go ahead and read it, and then we'll start into the audio of the actual hearing, and we'll play in sections. And if there's anything to discuss, we'll discuss it. If not, we'll just keep on rolling. So, plaintiff's opposition to the defendant's joint motion for order allowing defendants to depose plaintiff for 14 hours collectively. Defendants claim to need 14 hours to collectively depose plaintiff Colburn because they must explore the extent to which plaintiff's contact with Ms. Schuler waived the attorney-client privilege, and because plaintiff Colburn's complaint is lengthy and raises multiple areas of substantive questions. In addition, they claim that they are entitled to more time to depose Mr. Colburn because of the fact that this is a multi-party lawsuit. None of these reasons justify extending the time to take plaintiff's deposition to more than 7 hours. First, the fact that defendants have filed this motion jointly is consistent with the fact that they have presented a united front in this litigation. Defendants will be able to stay within the 7-hour time limit for deposition by ensuring they do not cover ground covered by another defendant. Second, the plaintiff does not dispute that attorney-client privilege is waived to the extent that Mr. Colburn revealed otherwise privileged communication to third parties, but maintains that communications not revealed are privileged. Given this concession, defendants will not need to explore Mr. Colburn whether his communication with Ms. Schuler regarding privileged communications result in a waiver of the attorney-client privilege. Third, the defendants claim they need more time because they must explore 8 areas of substantive questioning with Mr. Colburn, but with respect to 2 of those areas, whether the defendant acted with actual malice and whether the defendants acted with the intent to harm him, for example, by causing him emotional distress. Mr. Colburn cannot testify because he has no relevant information regarding these areas. In addition, questioning Mr. Colburn about statements of other people, including Mr. Avery's lawyers, made at trial will likely be brief because such statements can be confirmed by the transcript and film, and because Mr. Colburn did not allege large parts of the trial. Mr. Colburn did not attend large parts of the trial. Defendants claim that they need 14 hours to depose Mr. Colburn because of the length of the operative complaint is also misplaced. Like other witnesses, Mr. Colburn can only testify to the facts that he knows, and he will not know about each fact alleged in the complaint. In addition, the defendants have the benefit of Mr. Colburn's previous deposition and trial testimony, which should limit the field of questions about which they feel they must ask Mr. Colburn. Accordingly, the length of the complaint should have no bearing on how long defendants need to depose Mr. Colburn. 7 hours is sufficient. Plaintiff's counsel have adhered to the 7-hour time limit for deposing relevant witnesses, and there is no reason defendant's counsel cannot do the same when deposing Mr. Colburn. Defendant's motion should be denied. Dated July 5th. And that is from this lawyer, George Burnett. Okay. So this is the first document. So let's get this off. And if there's any questions, I have not been able to watch the chat. Alice, Rhonda, do we have any questions from the chat before we continue?
I haven't seen anything yet.
Okay.
No, we're fine.
Alrighty. Let me pull this audio file up here.
And that's a load of shite, I know. Them turning around saying that Colburn doesn't know about much of the trial and everything. He was sitting in the fucking courtroom and handing out fucking evidence in the courtroom. So he knows fine well what went on in the fucking trial.
Yeah, I mean, he's a witness to many things. And, you know, anybody that's went back and watched, you know, the documentary, Colburn, it seems to be kind of everywhere. You know, he's escorting Stephen, he's escorting Brendan, he's in the courtroom, he's outside, he's putting Brendan in the car, and even toward the end,
Jack.
he's everywhere. So, yeah, I mean, and then again, like I said, we add in this wrinkle of this third party connection, and we still don't know the depths of that because those texts are still sealed. We haven't seen them yet. Hopefully we get to see them at some point.
Aye. I mean, it still boggles my mind that officers that were taking the stand, like Fassbender and Weegar and fucking dipshit, were sitting in the fucking courtroom and able to listen to witnesses and everything like that. And they were also handing out evidence to witnesses in that friggin' trial. You know what I mean? I mean, here, the way it works here is if a police or any witness is a witness in a trial, they're not allowed to sit in the courtroom. There is a separate room for you to sit in called the witness room. And whether you're a police, whether you're a doctor or whatever kind of expert that is to testify in a court, you're not allowed to sit in that court and watch the rest of the proceedings, and then when it's your turn to go and testify, you don't go in the court that for that hour or whatever until you're testifying, and then go in and testify, and then go and sit back in the court again. It doesn't work that way.
Yeah,
you know what I mean? And it shouldn't work that way.
Well, usually
over there either.
Usually they don't. It's generally not allowed. And I remember there was I don't remember what Judge Willis said, but there was comment about that, about them being in the courtroom, and he allowed it. And in my view, typically they're not. If you're a witness in a trial and you're going to testify, you don't get to sit through the trial and listen, because you can tailor your testimony around what other people said. That's bullshit.
Exactly. And that's exactly what they've done. And I think this is exactly what's going to happen with this deposition on Ojak. They're going to go over, I mean, I suppose they don't know exactly what questions they're going to get asked, you know what I mean? But still, I guarantee you he's been told, if they ask you about Peterson, if they ask you about Kasurik, if they ask you about this or they ask you about that, just deny all plausibility. You don't know.
I think we're going to hear another repeat of Mark Rohr. I don't recall.
Yeah.
That's
yeah.
No doubt. All right. I'm going to get started. Anyone that's here in the Discord, you're going to probably need to unmute YouTube to hear this. So, all right, here we go. Let's play a few minutes of this and then we'll discuss.
Court calls case number 19CV484, Colburn versus Netflix. Appearances, please, starting with plaintiff.
George Burnett and Michael Griesbach on behalf of the plaintiff.
Lita Walker of Ballard Spahr on behalf of defendant Netflix.
James Friedman of Godfrey and Kahn on behalf of all defendants.
and Kevin Vick of Dassey, Vick, Carolyn on behalf of defendants Laura Ricciardi, Moira Demos, and Chrome Media.
So good afternoon, Council. We're here for a motions hearing. By way of background, this is a defamation case that started on December 17th of 2018. And a second amended complaint was filed on January 3rd of 2020. The case got reassigned to me in September of 2020. I entered an order denying various motions to dismiss on May 26th of 2021. A scheduling order was issued on July 28th of 2021 with basically discovery. The order required discovery to be completed in May, although there were some extensions, and Mr. Colburn's deposition, plaintiff's deposition, was yet to take place and was, I think, to be completed by the end of July. We have had a couple recent hearings on discovery motions, which the court resolved most recently on June 14th. The court granted a motion to compel and directed the parties to meet and confer on whether that the production in response to that motion to compel necessitated any changes to this existing schedule. The parties have since filed a status report indicating that no adjustments are necessary as a result of that. On June 24th, the defendants filed a motion to restrict a document. It is a confidential, it's the transcript of a deposition of a witness marked confidential, and some of it has been undesignated confidential and filed with the court, but apparently there's a portion of it that the counsel for the witness declined to consent to withdrawal of the confidentiality designation, so the defendants filed it under seal and along with a redacted version, consistent with the local rule, and filed the appropriate motion to restrict the document, although I think defendants do not maintain that it is properly designated as confidential. On June 24th, that same day, the defendants also filed a motion to allow an extended 14-hour deposition of the plaintiff. They argue that this is a multi-party lawsuit, a very lengthy complaint has involved extensive discovery, and there are various, I think, 8 aspects of plaintiff's claims that they think they maintain they need to cover with the plaintiff during his deposition, and that 7 hours, which is the presumptive limit under Federal Civil Procedure 30D, is insufficient. On June 28th, the parties filed their joint status report indicating no adjustments to the schedule were necessary, and then on July 5th, plaintiff responded to the motion for an extended deposition, objecting to it, arguing that there's no cause for more than 7 hours and that 7 hours ought to be sufficient. Plaintiffs note that plaintiff is a fact witness who can only testify to the facts within his knowledge, and that many of the aspects of the claims that defendants claim they need to explore are really outside of his personal knowledge. They also point out that much of the other information is available in other documents. There was also an issue as to attorney-client privilege waiver, and the plaintiff concedes that in the response. So we're here today. So I tried to set, I know the depositions are upcoming. I want to make sure that we get discovery completed promptly. So I set this for a hearing on short notice to try to work through these things. Again, these are a lot of these are issues that I would expect counsel to be able to work out amongst themselves without bothering the court, but obviously that did not happen here. So let me take these one at a time. First, there is this issue with the motion to restrict the document. And let me start with defense counsel. I'm not sure who's taking the lead, but am I correct that this is a deposition of a third-party witness, and that witness's counsel designated this material confidential under the confidentiality and protective order, and that they withdrew most of it but not all of it, and now so the defendants do not are filed it because they wanted to file it in support of the current motion, but the defendants actually do not believe that this material should be I guess, confidential to the point that it would be required to be filed under seal. Is that correct?
Yes, Your Honor, that's correct.
And the portion that was, I reviewed the portion that was redacted, and then I reviewed the portion that was unredacted. It wasn't entirely clear to me what the portion redacted covered. Is it the portion that talks about the confidential mediation? Is that the part that has remained, or that the witness's lawyer seeks to have maintained confidential?
That was what I took away from it, yes, Your Honor.
And did you have is there any, well, let me turn to plaintiff's counsel. Mr. Burnett and Mr. Griesbach, what is plaintiff's position on the confidentiality of the portion that is redacted?
We take no position on that, Your Honor. We didn't participate in the redaction.
And Mr. Vick, what is the rationale that, if any, that was given for maintaining that portion redacted?
I don't recall a specific rationale, to be honest, Your Honor. Just we provided it. We let Ms. Schuler's attorney know which pages from the deposition we intended to include with our motion, and we asked him for his position regarding whether he was maintaining that any of them were confidential, and those were the ones that he identified that he was maintaining are confidential.
And who is the lawyer for the witness?
The attorney's name is Nicholas Kurtz.
Your Honor, if I could interject here, I have been in touch with Mr. Kurtz because we're still trying to get some documents responsive to a subpoena we served on his client, Brenda Schuler, whose deposition transcript is at issue. I made sure he was aware of this motion, and I told him that given how you dealt with a similar motion the last time around, you might be asking him for a statement of good cause. This was last week, maybe several days ago anyway, and he indicated he understood that and was prepared to file something. I don't believe he has, however.
So it's hard for me to see what reason there would be to keep this portion restricted, filed under seal. But what I will do is I'm going to allow him 7 days from today's date, so until July 14th, to file, if he chooses, a brief explaining why these materials need to be maintained under seal on the court docket. If he doesn't file anything by July 14th, the motion to restrict will be denied and the documents will be unsealed. If he files something, I will take it under advisement and consider it. And if I need if I need more briefing or more input from the parties, I'll docket something. But I suspect I'll be able to rule based on what he files. So that's how we'll deal with that issue. Any questions from any of the lawyers on that?
No, thank you, Your Honor.
None, Your Honor.
No, and I'm happy to let Mr. Kurtz know about the 7-day deadline.
Thank you. I will. Thanks for volunteering. I will include that in the minute order. Then the next issue is.
Yeah, I'm going to pause it right here before we continue with the next issue. I'm sure Sapricop knows my feeling. A lawyer says, well, I really don't know why they wanted it sealed. That's not really a good answer to a federal judge.
Yeah, we don't know. We just really want it sealed.
Yeah,
and go ahead and do that for us.
Yeah, thanks, Jeff. Yeah, just knowing what we've seen so far of Judge Ludwig, like I've maintained, I think he's a really fair, measured. He's a bit undecisive at times, but I think he likes to make sure he makes the right decision before he just snaps one off. So I kind of respect him for that. But I also think that, if you come into court, come to basically, I mean, to me, this is like coming into court because it is an official hearing. You really need to be prepared. And that, to me, that was not a good reply. It just wasn't.
No, he's definitely very accommodating. Probably more accommodating than a lot of judges. I think there was a lot of judges that would have said, "Oh, they didn't file anything yet." Well, they're, then denied.
Right, unsealed. And I do know that I can't remember. Someone looked. I don't know if this guy filed anything. I just know that somebody looked yesterday, I think, or maybe Friday, and there was nothing unsealed yet. So I keep hoping that, I think it's documents somewhere around the 219, 220, 221. I want all that shit to be unsealed, and it's still not unsealed yet. So, but anyway, so I'm not going to belabor that too much. I just think that it's a really bad maneuver for any lawyer to come in and just give an answer, I don't know, to a judge, especially about something that seems to be relatively important. So, all right, let's move on to this next section here.
Pete Norson chat is asking, does anyone know where Andy is getting the financial backing for all of this?
Well, I think that I don't know this, but my guess is that this has been taken on contingency. So basically, if his side doesn't win, the lawyer just eats it. If they win, if they win a percentage, if they win, I'm throwing a number out here. This is purely hypothetical. If they win $10 million, generally, guys, you have to back me up, but generally a contingency for a lawyer in a civil suit is 30 to 40%. So let's just say that he won. Let's just say he won $10 million. The lawyer's going to get $4 million out of that. If it's 40%, it's somewhere in that range. So, we're moving into, let's see, we're 3.5 years into this lawsuit. It was end of 2018 when it got filed. So I don't know that for sure, guys. I don't know if this is taken on contingency or if he has some kind of financial backing that's feeding money to Griesbach and these other lawyers. I really don't know.
Yeah, I mean that's typically how it works for civil trials. Is you're in for the win, and if you don't win, you just blew a bunch of money for nothing. Really, is how it comes out to. There can be rare instances for big high mucky muck lawyers, where they get what really kind of amounts to a special retainer kind of fee, but I doubt that's the case here because it's frickin' Griesbach. So.
Yep. Alrighty, let's pull up and we'll get into this next part. I think this lawyer Vick is going to speak for a bit, so I'll back it up 10 seconds, and then we'll continue.
Thank you. I will. Thanks for volunteering. I will include that in the minute order. Then the next issue is the motion for the double length of deposition. Again, I'll start with defendant's counsel because it's your motion. You're the one seeking the 14 hours. My question is, why is it that you think 7 hours are insufficient? And in answering that, I realize that certainly Mr. Colburn is a central witness, one of the central witnesses in this case. But it strikes me that while this is a defamation case and maybe a little more high profile than many of the cases we have, many of the diversity cases we see, it which really isn't that much different than any other tort claim diversity lawsuit. And so the presumption is 7 hours. I realize that there are multiple defendants here, but it seems to me the defendants are essentially aligned in terms of their arguments, their issues. And it also seems to me that, in terms of defamation and intentional infliction of emotional distress, those are two tort claims, but it's not all that uncommon for a diversity case that we see to have, or it's a tort claim to have multiple tort claims and multiple legal theories. And usually 7 hours is enough to cover those. A lot of the facts that the aspects of the plaintiff's claims that were identified in defendant's motion seem to be facts that are in defendant's possession or knowledge, much more so than the plaintiff. I think obviously the actual malice issue, which is at the forefront of these types of claims, something that plaintiff is likely not to have a whole lot of factual knowledge of. That's something that's going to be within the defendant's knowledge. Damages, certainly, I get that. But in mitigation, I agree that those are all things to explore. But again, those things happen in every tort case. And so defense counsel has to, is expected to be able to adequately investigate those things in 7 hours. Anyway, that's my long introduction to saying, what makes this case so different from the standard one that you need more time, and why an additional 7 hours, which is like a lot. Go ahead.
Thank you, Your Honor. I appreciate the question, and I'll do my best to answer it. I think it's interesting that you brought up the idea that there's this presumptive 7-hour limit, and that's something that you anticipate that in your garden variety tort case should be sufficient. And in a simple, straightforward defamation case, I think it would be. In a simple, a sort of ordinary defamation case, it might involve an article that's, a couple pages long. There's a couple challenge statements that plaintiff has zeroed in on and is claiming are allegedly defamatory. That's sort of your typical defamation case. And in a case like that, it would probably take, if not 7 hours, still pretty close to the 7 hours to cover the standard lines of questioning. I'm getting a lot of static on my end, Your Honor. I don't know if that's just me or if that's everyone else.
If for the rest of the parties, it sounds like somebody's maybe walking outside in the wind. If you're not talking, if you can mute your phone, that would be great. Thank you. Please proceed.
Great. Yeah, I can hear much better now. So in that standard case, there's the standard lines of questioning: plaintiff's background, the underlying events leading up to the article at issue, the article itself, this handful of allegedly defamatory statements, actual malice, claim damages, mitigation of damages, the key issues related to certain defenses, the sort of things that Your Honor was talking about. And even in that sort of standard, simple, relatively straightforward defamation case, I can say from experience, you may not, if it doesn't go the full 7 hours, it's likely to go, 5 or 6 hours. We've had depositions in this case already of third parties that have gone close to the 7-hour limit. So that's just your sort of relatively simple, straightforward defamation case. However, this case is very different than that. This case is far more complex, and that's really why more time is needed. Now, it starts with the complaint here. The complaint here is 56 pages. It's got pages and pages of allegations about the substance of Making a Murderer itself being a 10-hour documentary series. Those allegations themselves, they relate to events that stretch back to 1985 and continue forward through, at least the trial of Stephen Avery and Brendan Dassey in 2007. Now, besides those allegations in the complaint itself, there's Exhibits A and B to the Second Amended Complaint, which contain lengthy compendiums of things about which plaintiff is complaining. To expand the world even farther out, you have Sergeant Colburn's interrogatory responses. We served interrogatory responses that, among other things, tried to get at the bottom of, okay, what are all your complaints? What is it that you're saying was done wrong? The interrogatory responses that we've received are about 70 pages. Netflix has gotten 15 pages more. So in contrast to your average garden variety defamation case where you might have, a couple of challenge statements, we're dealing with a much larger universe here. As Your Honor also indicated, Sergeant Colburn also has an intentional infliction of emotional defense claim. That means that, there'll be additional questions there above and beyond those having to do with defamation, addressing the elements and key issues and some of his claim damages that he's claiming under that claim. Now, we tried to streamline discovery considerably by serving some RFAs that I thought were pretty non-controversial, but they virtually all got denied. These were ones that are going to further require us to go into some detail and to, ask him, okay, why are you denying this? Why are you denying that Avery's defense attorneys made certain contentions at the trial? So that's going to take more time. And also, underlying all of this is Sergeant Colburn. He chose to bring a single lawsuit against 4 separate defendants, Netflix, Ms. Ricciardi, Ms. Demos, and Chrome Media. He's seeking more than $10 million from each of them. So that means that each defendant here is facing considerable financial and economic risk. They're also facing, professional risk, reputational risk. I can tell you my clients, they take this lawsuit very seriously. He's made very serious allegations about the integrity of Making a Murderer and about their professional representations, in addition to bringing claims that have really put their personal financial situation on the line here. Now, under those circumstances, each defendant deserves the opportunity to ask Mr. Colburn the questions that are necessary to fully understand the bases for his lawsuit and to evaluate and continue developing the defenses to the lawsuit. The stakes are high, very high, and there's so much ground to cover. Now, Your Honor has said that you think, well, it seems like the defendant's interests are aligned here and there's things in common. That's true to a point, and undoubtedly we will be able to avoid certain duplication of questioning by nature of the fact that there are issues that overlap and that we have interests in, and we can sort of try and get things coordinated in advance to make that more streamlined, because the last thing we want to do is duplicate the questioning, is just make it needlessly long. But there's other issues where the interests, could be different. They can have different points of emphases, different areas that Netflix wants to cover that, for example, my clients might not, and vice versa. The question of actual malice is going to be different as between the defendants to a certain respect. There's allegations in the Second Amendment complaint about Ms. Ricciardi's and Ms. Demos' knowledge about certain alleged information that are not made out to Netflix, so I would anticipate those would be ones that I would have to go into in more detail in terms of asking Mr. Colburn why he believes certain things that he has alleged in his complaint, and that Netflix may not. It's also worth remembering, originally in this lawsuit, this was before Your Honor came on the scene, there was one set of lawyers representing all defendants. A couple years ago, that changed, and the Ballard Bar firm still represents defendant Netflix, but my firm entered the picture, and we're representing Ms. Demos, Ms. Ricciardi, and Chrome Media. So while there are some overlapping interests, these are distinct defendants. Mr. Colburn chose to sue all of us. He's chosen to sue, not all of us, literally the attorneys, but the parties. He's chosen to bring a lengthy lawsuit against the 4 defendants, and they each have a right to ask him questions. Now, there's also things that have arisen in this litigation that give us reason to believe that deposing Mr. Colburn will present really somewhat unique challenges that are going to mean that his deposition is going to take longer than that of a typical defamation plaintiff. I would say first and foremost is the fact that he has indicated in discovery and in communications with various third parties that he has never even watched Making a Murderer. He's filed this lawsuit. We've been going on for years. There's been just incredible amount of discovery and burden. But apparently Mr. Colburn has never watched the documentary about which he's complaining. That means when we're asking him questions...
Shouldn't that make the deposition shorter?
No. I think that's what Mr. Colburn stated in his opposition, but the contrary is actually true, because these are the allegations that he's making, that he has to stand behind, consistent with Rule 11, among other things. And that means that we're going to have to spend a certain amount of time...
His lawyers are the ones that drafted the complaint. He's a fact witness, and they may have all kinds of strategic reasons for alleging what they've alleged, and certainly it will be his and his lawyer's obligation to prove it. But I would be shocked if an individual defamation plaintiff has firsthand knowledge of all of the things that his lawyers have alleged in the complaint. It's not a
That's undoubtedly true, Your Honor. If this was a case where we were thought that he's going to have personal knowledge about everything in that 56-page complaint, candidly, I'd probably be asking for 28 or 35 hours, not 14. So I do think the fact that he doesn't know about certain issues will cut down things in certain aspects. But there's other issues where he's making allegations saying that is false, allegations where he has at least purported personal knowledge. And he's saying not only is it false, but the way that this is depicted in Making a Murderer is misleading. So that means we're going to have to orient him. We're going to have to spend a certain percentage of this deposition showing him the portions of Making a Murderer about which his complaint complains, for example. That's going to mean it takes more time to go into detail on those, to provide the context, to get him up to speed than we would face in a normal case in which the plaintiff at least, had watched the documentary before he filed suit. So that's an instance where I actually think that's going to end up lengthening things. Now, Mr. Colburn's complaint is also it's not just about certain statements or alleged implications, but also things like the music, the graphics. There's a list of numerous, what he calls omissions that he would have liked Making a Murderer to include. Those are going to take more time. There's also the fact that Mr. Colburn has complained in documents that we've seen in discovery and elsewhere about numerous statements that either appear or are alluded to in Making a Murderer, but that were first made by Mr. Avery's defense team, or that were first made by other members of the media or reporters or people looking into this issue back in 2006, 2007. You have John Farrick, a reporter who covered it in depth at the time and then subsequently wrote a book about it. So you've got a situation where Mr. Colburn is complaining about statements that get repeated. And sorry, I believe you were asking something.
But my point is, if that is all true, that's true. That's true regardless of whether he says it or not. I'm not sure if somebody else, if a member of the defense team or if some other reporter reported on something and the documentary repeated that, that's a fact. It is what it is. Asking Mr. Colburn about it as a fact witness isn't going to make that fact more likely or less likely to be true. Sort of irrelevant, and whether he knows that or doesn't know it, I'm not sure how that moves the ball forward in terms of the legal claims. So I appreciate there are lots of issues, but it still seems to me that a lot of the stuff you're talking about is not something that the plaintiff as a fact witness is going to have any knowledge about, and you can ask him if he has any knowledge about it, and if he says, "Oh, I didn't know that," I'm not sure what more questioning one would do on it. But anyway, continue your argument. I apologize for interrupting.
No, it's a fair question, and I'll answer it, Your Honor. It goes to the issue of proximate causation of damages. Mr. Colburn has claimed that Making a Murderer defamed him, injured him, caused him all this damage. But when it's allegations that are first made by Mr. Avery's attorneys in connection with the criminal trial, are then made in the media, often by many different members of the media, television, print, etc., books, And then they're made in Making a Murderer, and he's laying it all at the feet of the defendants in this lawsuit. It's important to ask him questions about the timeline, the sequence, his ideas for why these claimed damages, A, to the extent to which they really exist, and B, how is he claiming that the defendants who he is suing in this lawsuit have proximately caused them. So that's an example of a situation where these sort of layers, the historical layers that we're dealing with, add levels of complexity that will require additional questioning above and beyond your typical defamation suit. That ordinary case where I grant 7 hours should be sufficient. Now, so far what I've talked about is the standard questions that we have to ask Mr. Colburn about. There's also some non-standard stuff that's come up. I mean, there's the connection between this lawsuit and Convicting a Murderer, the so-called counter-documentary that's designed to be a response to Making a Murderer. Its executive producer, Brenda Schuler, whom we talked about earlier with respect to the motion to restrict, it turns out she drafted portions of Mr. Colburn's complaint. She also served as a fact-checker for his attorney, Michael Griesbach's book, and she provided substantial input to Mr. Griesbach and Mr. Colburn for this lawsuit. She testified as to many documents and materials that Mr. Colburn handed over to her. We want to ask about those documents. We want to know what he gave her. We want to make sure we've gotten everything. We want to know what Mr. Colburn discussed with Ms. Schuler and Mr. Griesbach, because Ms. Schuler's presence there, even leaving aside Your Honor's ruling last week on the motion regarding Mr. Griesbach, we contend that there's been a waiver of privilege and that we're entitled to know all the substance of those conversations that went on. We also want to ask more about what transpired, how it is that Ms. Schuler learned about what happened at the court-ordered mediation before Magistrate Judge Duffin that was supposed to be confidential. She also, Ms. Schuler, testified that, convicting a murderer, it's going to make Stephen Avery look guilty as heck and humanize the hell out of Andrew Colburn. Well, Mr. Colburn's allegations in this lawsuit is that, making a murderer is biased. It's unfair to him. So we want to ask him a little bit about, what are the viewpoints that documentarians can have? What is fair, what is not fair, and we want to know about this exclusive agreement that he signed, apparently, with the Convicting a Murderer documentary filmmakers. That's going to go to issues like mitigation of damages. It's going to go because it turns out that maybe he's been restricted from speaking out publicly and stating his side of the story with regard to certain issues. We want to know about, to what extent, if any, this lawsuit has been connected with the efforts of the Convicting a Murderer producers to spark interest in their project, including finding a distributor for the documentary, marketing, publicizing, etc. And so these are other things that we'll want to go into. And that leads me to another issue that we're going to have to go into, which is
Yes, Linda. Okay. I'm sorry, I missed it. I'm trying to keep up here. What issue is he wanting to discuss? Did anybody see that? Crockett wanted to discuss something?
He wants to know who is speaking.
Who's speaking, yeah.
Who is speaking?
Yeah, who's talking? I know it's one of
he's
the attorney for Moira and
yes, this is Michael. This is Michael Vick.
Michael Vick, that's right.
Can you tell us when Griesbach's talking again? Because I don't know which voice is his.
Oh, you won't need to be told. You'll know.
No, I can't tell. They sound the same, some of them, so it's hard to say.
Yeah. I'll tell. I'll make note of it. I don't think he talked.
When you hear somebody start talking and they sound really stupid, that'll be Griesbach.
No doubt. Yeah,
I'll keep my ears open.
Yeah, you can't miss him, but I will when he comes on. I will make a note of it. Well, we can discuss a little bit here, about because he's brought up a lot of different things, and in fact, he's not wrong entirely. I think he's piled on quite a bit, but the truth is that there are a number of lawyers. They have changed, and there are a number of issues that have been added, and part of it, coming this year alone, and that's the third party stuff with Brenda Schuler and Convicting a Murderer. So we don't know yet what could come out of the deposition itself that could actually extend make them go longer than they originally planned. So I don't think that they're necessarily wrong. I get why Colburn's lawyers are resisting, the judge forcing that issue, but I get it.
The part that still kind of confuses me, and the judge has alluded to it, is this idea that Colburn doesn't have to have knowledge of everything he's suing about, which that blows my mind. So kind of what they're trying to say is, I can walk into a lawyer's office and say, I want to sue for defamation. I don't know anything about this, but I feel like I've been defamed. So you go find all the facts and file the suit. That's kind of what they're trying to make it sound like is happening. Like, Colburn never watched Ma'am, so he doesn't have to know all the facts about Ma'am to allege he was defamed. Well, how the hell does that work? How can you know you're defamed if you've never seen that thing that you claim defamed you?
I remember reading that shit in the emails from, started back in early 2016, and I'm like, wait, you never watched it, but you're suing? How the hell does that work?
Yeah, exactly. I don't get that part, and it almost sounds like the feeling I get is the judge is not going to grant any more time other than the 7 hours. I don't get the feeling he's going to, but and I kind of see what he's saying, but Mike has made some really great points, and I don't know how they could argue against that, because there are so many doors that have been kicked open with Colburn doing the stupid shit he did, with including Brenda and Sean, and then flipping lawyers halfway through, and all of that garbage. I don't know.
You're not wrong at all. And going up from that, I suspect there's going to be more doors kicked open during his deposition, and I think that's going to lead to more time. I think you'll like if you haven't, I have heard this actually twice. I think you will like what the judge does in this. I think it's fair, and so we'll see. Is there anything else we need to address? We don't really have too much longer.
Just quickly, Jack, Marty H has joined us in chat. Hello and welcome. They said, if someone's actions in life are unsavoury, putting it nicely, how can they sue people making a documentary for defamation? His actions were the cause of his defamation. Yes, exactly. Wholeheartedly agree. It was him and his actions that got him in the situation that he's in now. The same way every one of them, Kratz, Aspender, Liger, the lot of them, it's all their own faults because of what they've done in this case. And I'm surprised that it's Colborn that's actually trying to get this. And 10 million for each episode. Are you fucking kidding?
Well, another thing that is really surprising, to be fair, and we have to be fair, and I'll take this just briefly, I'll just explain what I'm saying here. We see snapshots of time, and we can see this throughout anyone's particular life that's, been on a documentary. We see a snapshot, and it may turn out good or bad, and that we kind of form this perspective of that person. So, as we look at Making a Murder and the actions that we see in these snapshots of Andrew Colburn, they're really not very favorable. And I don't say that with any malice. I'm just saying that was my perspective and my opinion. I'm not saying he's a bad person at all. That's not what I'm saying. But I think it's a little unfair that we completely judge someone based on just these snapshots. Now, with that said, I also look at him as a police officer and the actions that he basically didn't take, writing a report, on this phone call. Now, I know that he was kind of forced into this memo in 2003 of a call that happened in 95 or 96, whatever the hell. But there are other issues that where he didn't write a report. The one, where he went to Avery's in early, whatever it was, November, whatever damn day it was, 4th or whatever it was, 3rd or 4th. And he didn't write a report for the 3rd. The 3rd. He didn't write a report for 8 months. And that's really bad policing. We need to base that. We need to judge, I think, a little more closely as to how is he with other cases that has nothing to do with Brendan or Stephen. Is he more responsive in writing reports and getting this turned in a timely fashion? And I mean, within a week or two. To me, that's timely. It really, if it's I just, this is the way I see it. So that was kind of a long-winded way of saying, of getting what I was saying. But anyway, go ahead.
I was going to say, we have to remember that the majority of these folks, Colburn, Uyghur, Fassbender, all of them, none of these guys consider themselves unsavory because they know that there's stuff that they've done or said that may never be found out. So because we'll never find out, we can't prove they're unsavory. We can take bits and pieces from all these different areas and make a kind of a collective picture that creates that. And that's kind of where I was gonna say I agree with you to a certain point. But if it was just one piece, if it was just his trial testimony that made him look that way, that argument could be valid. But unfortunately, he did so many other different things and was involved in so many other different areas where his lies are provable from a common sense standpoint that we're able to make that collective picture. And unfortunately, Colburn is one of those guys. He was one of those outliers. He was one of those kids on the playground that nobody wanted to play with, but you felt bad for him and he wanted to be part of the crowd. So he did whatever he needed to do to get into the good old boys club, to be part of the clique.
Yeah.
And he kind of did that to himself. So he made himself unsavory, even if he wasn't necessarily by nature. He created himself that way.
The persona, the perspective. Yeah. I get what you're saying. So, I do. Well, I think it's in
convictions.
Yeah.
Checking convictions in chat, it says he shows ability on his own. He looked just like he is, in my opinion. They feel they were within the law.
Yeah, I mean, yeah, I think so. And it, from a cop's perspective, depending on what he's trying to do, if it's to help the case, I pick on the key a lot because I know what we see in the documentation and the photos that we have versus what happened at trial, the testimony that was given by Colburn, Lincoln, and Kucharski, and then Kratz running from that key in his closing. And I know openings and closing are not evidence. I get that. I kind of had a little bit of this argument here the last couple of days on Reddit. I don't remember exactly what it was. Somebody posted about, what evidence was talked about on the stand. They narrowed the focus here. That's through planting or to discuss planting of evidence. And the key to me is a huge red flag. What prosecutor would go in and present all this stuff? 3 cops get up and talk about this damn thing and then get to his closing and say, you know what? Screw that key. Let's just set that son bitch aside. You don't need to talk. You don't need to consider it. Well, how would you do that? I'm telling you, I would have been on fire as a judge. My hair would have lit.
Yeah, the key's one of the big ones for me when it comes to Colburn, because Netflix didn't create that story. Colburn created that story.
That's right.
He said it on the stand. He said it in reports. He said it in interviews. He was the one that concocted this absolutely unbelievable story that had nothing to back it. So that's what comes into my mind when I think of Colburn, even less than his testimony on the stand where he looks like a dumbass. It's this story. I can look at that story just about the key and go, that's the dumbest thing I've ever heard in my life. How can you possibly hang your hat on that? And to go even a little bit further on all these folks is, remember, they've been telling the same lie for years. So you tell a lie long enough, you believe it. And that's where these guys are at. They've told this crap the same way for so long, they believe it.
Well, and he made it worse because remember, after it was all said and done in 20, I don't even remember what year it was, he wrote that letter to Peterson after he had retired, right? And changed the story again.
Yep.
I'm just wondering if they'll question him about that during his deposition, because it's part of it, you know. And so anyway, I've kind of rambled on there about, you know, perspective about people, and I get that. And I think we have to be careful, but I think, you know, between what I said, my Sapper Cop and other people said, I don't think we're wrong. I just don't.
And I think one area or one something that Colburn maybe isn't thinking about is he's relying on just the footage from the documentary to say, this is why people see me as unsavory. I don't know if he realizes that all of his reports, all of his interviews, everything about him is out there. That's what we're basing it on. We don't even talk about the documentary anymore. It's everything else that we had access to that creates that. I don't know if Andy's thought that far. Oh, I agree with you 100%. I guess I think about the documentary every once in a while, but we've come a million miles from a documentary in my mind. I don't know about everybody else. Yep. So, you want to read that, what Linda wrote, that last comment, Alice? Linda said they did things that were so easily showing fucked up. That is the way they got away with it. Would any Department of Protection for the People ever do such things? No, is what the locals would say. Yeah, I can't disagree. Probably any local town in any state. Bethany says, I'm starting to think that this judge wants the truth to come out. Sometimes you have to spill a little honey to catch in the berry. Yeah, that's true. That's true. All right, let's continue on. We've got looks like we've got about 24 minutes left to go. So let's play a little bit more. We may need to stop one more time. We'll see. I'll back it up 10 seconds so we're back in the loop here. All right, here we go.
Including finding a distributor for the documentary, marketing, publicizing, etc. And so these are other things that we'll want to go into. And that leads me to another issue that we're going to have to go into, which is discovery. Now, a simple defamation case, it's going to have pretty limited discovery. You know, often in defamation cases, one of the things that candidly I enjoy about handling these cases is they're not discovery heavy. They are more simple and straightforward and more often that way. This one, however, is not. Sergeant Colburn himself has produced thousands of pages of documents. In addition, thousands of texts, including about 4,000 with Brenda Schuler. We've had third parties, including Sergeant Colburn's former employer, the Manitowoc County Sheriff's Office, has produced tens of thousands of pages in response to various subpoenas. We've gotten very significant productions as well from Calumet County and from the Wisconsin DOJ. Now, my own clients, we've produced, I think, almost 50,000 pages to date. Between the two of them, my clients, Ms. Demos and Ms. Ricciardi, they spent about 300 hours of their own personal time responding to Mr. Colburn's 7 sets of requests for production. That includes, searching for responsive documents, reviewing documents. They both spent many, many dozens of hours duplicating certain footage that Mr. Colburn requested in discovery and then quality checking that we then provided. They sat for 7-hour depos each. Actually, Ms. Demos's deposition went more than 7 hours. I think it went about 7.5 hours. Now, I didn't object because she was sitting there. They were asking. This is discovery. Sometimes things take a little bit more time. So I didn't stand up after 7 hours and say, I object. I let it go on. I let it conclude until plaintiff indicated that they were done with the questioning. So now that's what happened with the 2 Netflix executives as well. They both sat for full-day depositions, as did Ms. Ricciardi. There have been depositions of Eleanor Daly, who worked with Crow Media back in the day. And then just last week, there was a nearly full-day deposition of Mary Manhart, who's a third party who was one of the editors on Making a Murderer. Now, she's not even a party to this lawsuit, and plaintiff's counsel went almost, I think, probably about 6 hours on the clock with regard to Ms. Manhart. This is all to show that there's been incredible burden. I feel like we've been eminently reasonable on the defense side in terms of what we've allowed, what we've been willing to do. And under these circumstances, and given this great complexity of this case, and given all the issues that we have to cover and how much more there is than in your average garden variety defamation or even defamation plus IEI, intentional infliction of emotional distress claim, I don't think it's unreasonable to now ask Mr. Colburn to sit for 14 hours of deposition so that all of the defendants that he's chosen to sue get a fair opportunity to question him in this lawsuit that he's brought against all four of them for more than $10 million each, and that they are facing at extreme personal, professional, and financial peril. Thank you, Your Honor.
All right. Mr. Burnett?
Yes, Your Honor. Just a few thoughts. In listening to Mr. Vick's comments, I think there's a fundamental disagreement between the parties as to what the purpose of a deposition is. It sounds like, in Mr. Vick's mind, the purpose of Mr. Colburn's deposition is for Mr. Colburn to defend the lawsuit he has brought, to explain to the defendants each and every element of his case, each and every aspect of his complaint, and justify it. That's not the purpose of a deposition. The purpose of a deposition is for the defense to have adequate opportunity to question a witness about what he or she knows. Nothing more, nothing less. Now, what I heard was a long list of the various issues in this case that the defense intends to raise, and that's certainly their prerogative. But Mr. Colburn can't answer most of those questions. I heard a lot of things that left me a little puzzled. You know, we heard about Ms. Schuler helping draft Mr. Griesbach's initial complaint in this case. Why that's a subject matter here in this case now when that's not the operative complaint? I don't know. I heard that somehow or other Mr. Colburn demands $10 million from each of the defendants. I don't know where that comes from. No one's ever asked me for a demand. I heard that the defendants are represented by separate counsel and therefore working separately and independently. I would point out that Mr. Friedman, their local counsel represents each of them. And they have been working hand in glove, which is, of course, their prerogative, and their interests are largely united in this case. I still don't have a good explanation, haven't heard a good explanation as to why 14 hours, which seems quite extravagant to me, is necessary to plumb all these depths. And I did offer a compromise. I understand this court is going to allow the defendants to question Mr. Colburn so as to discern what he knows about the various issues in this case. And after reasonable questioning, if they can't complete it in 7 hours, I told Mr. Vick that I would let it go further. But he and I are both at a disadvantage here of trying to anticipate what questions are going to be asked and what answers are going to be received. My dealings with Mr. Colburn have been rather straightforward. I don't think he's going to be an evasive witness. He certainly didn't appear that way in his trial testimony or in his deposition testimony. So my compromise to the defendants, which was unacceptable, was let's see where this goes, recognizing that Judge Ludwig is going to make sure that everybody has enough information from various witnesses so as to defend this case. I don't want to repeat what I've already said in briefing and in my June 6, 2022 email, where I essentially laid out our position on this. I just don't think that different rules should apply to different litigants. We have confined ourselves to 7 hours of questioning, with perhaps the one exception that Mr. Vick mentioned. I don't know how long Ms. Demos' deposition went because I wasn't at the entire thing. But it doesn't sound like it went much further than 7 hours. And of course, if that's the situation with Mr. Colburn, I would afford the same courtesy.
Thank you.
Your Honor, may I say a few words as well?
Sure.
So a couple of things Mr. Burnett said that I just wanted to address. First, he
This
said
is
he
Leanna
didn't
Walker.
know where the claim for over $10 million had come from, and I will represent to you, and I'm happy to provide them, that came from Mr. Colburn's responses to interrogatories. He put that in writing. And with all due respect to Mr. Burnett, he has not been particularly involved in this case. He swoops in here and again for this deposition and one other in the case, and for the most part hasn't even attended the rest of them. And so to the extent he's confused about why some of these topics are relevant, I'm not surprised that he's confused. As to his point that he does not think Mr. Colborn would be evasive, I wanted to emphasize what Mr. Vick started to tell you about the request for admissions that were served upon Mr. Colborn. His responses to them were extremely evasive, and I'll give you an example of how. There were very straightforward questions in those requests for admission to the effect of admit that Avery's defense team at trial contended that law enforcement planted evidence to frame him. There was a series of questions like that. Admit that it was Avery's defense at trial, that. Admit that it was Avery's contention at trial, that. And in connection with every single one of them, Mr. Colborn denied them on grounds that the definition of content is to assert in a strong and definite way, and that because they didn't assert these defenses in a strong and definite way, they didn't contend them, and therefore he can't admit that these things that he's complaining about in his complaint against Netflix were first raised by Avery's defense at trial. So if we're quibbling over the definition of content, I really struggle to see how Mr. Burnett can say his client is not going to be evasive at the definition, at the deposition. So just two more points briefly, Your Honor. I, too, am concerned that Mr. Colburn hasn't taken 10 hours over the course of 3 years to watch the very documentary that he's sued over. And I completely agree with Mr. Vick that means this case will take more time because his counsel have conceded, as they must, that defamatory statements, alleged defamatory statements, have to be viewed in context. And in this case, context means within a 10-hour documentary. And so Mr. Colborn, whether he's done it himself or whether he's been led down the path by his counsel, has cherry-picked statements that in isolation he believes are misleading. But we're going to have to show him minutes, perhaps an hour or so, off and on, of the documentary itself. And then lastly, Your Honor, I take the point in Mr. Burnett's brief and points that you've raised today that we have a documentary, we have a trial transcript, we have deposition transcripts, and that those things should speak for themselves. But that is actually what we argued at the motion to dismiss stage. We said to the court, look at the trial transcript, look at Making a Murderer itself, look at the third-party news reports that were out there. As a matter of law, you can assess these things. We don't need discovery. They speak for themselves. This case should be dismissed. And we lost that motion. And the reason we lost it, and I'll take the risk of quoting the court's order back to it, is because in docket 176, the court said, if the record at summary judgment establishes that defendants reporting on the Avery case was substantially true, then they will be entitled to summary judgment. But we were sent back to do discovery in this case to prove substantial truth, despite the fact that there is strong record and written evidence of many undisputed facts in this case. And so that's where we're at. That's what we're trying to do now, because we weren't able to do it on the transcripts alone, and that is going to take some time.
So on that last point, the transcripts, all of that stuff, those are factual issues, and I know there's case law that talks about in certain motion to dismiss contexts, the court can look beyond the pleadings to factual materials that are not disputed, contracts, things like that. But at the motion to dismiss stage, the parties were throwing, especially defendants, were throwing a lot of factual material at the court. And I think at least in one of the early hearings, I suggested that that it really seemed like a motion for summary judgment to me, given all the materials that were put in play, or the defendants were trying to put in play. And if I treated it as a motion for summary judgment, I think I said this at a hearing. If I did that, if I went that far and denied it, I wouldn't be giving you a second shot at summary judgment later on after discovery. And we ended up proceeding with the motion to dismiss, and the court ruled as it ruled. But we don't need to go further down that road. But that's just a little, I guess, of my response to that argument.
I'm going to pause it right here for just a minute so I can really kind of bitch about this whole presumption that Colburn has not watched the documentary. He didn't watch it, in late December 2016 or 15, and then, gets so damn mad that he felt like that he'd been shown in such a bad light that he had to go after Netflix and the filmmakers. And these other entities that are involved in the lawsuit for millions of dollars. I just got to call rubbish on that. That's my opinion. I'm not saying that I'm right, but how can someone get so angered that they would file this multi-million-dollar lawsuit against several entities, and they haven't even viewed the program? I find that really difficult to believe. Anyone else got?
Is all I've got to say. That's a load of rubbish, Jack. Of course he's watched it. Why would he be bringing a defamation case if he's not watched it? Because how is he meant to know what defamed him in the first place? What actions or what part was in that 20-episode series that defamed him in any way whatsoever for him to bring this case? You know what I mean? That is just a load of bollocks.
Well, if he hadn't watched it, how could he possibly know? I mean, even if he didn't watch, this is really based on the first part, but
yeah, it's just has somebody watched it and then went to him and says, "Oh, here, by the way, they made you look like a fool. They made you look like this. They made you look that," and he's just went out and decided to sue them? I don't think so. I don't think so for one fucking bit that's how it is. He sits because we've got emails between people saying, "Are you coming over for a drink so that we can watch Netflix?"
Oh yeah, that was the reporter. That was Emily
Matesic.
Yes, right, Matesic. Yep, Emily Matesic. Inviting him over for drinks and
Reminger was the one who wrote those letters to the county lawyer or whatever about Jacobs and Colburn basically being, made out to look like the bad guys in the show.
Yeah.
And that lawyer was like, "Suck it up, Buttercup."
Well, basically, he wasn't the only one. They really went after. Kratz looked really pretty terrible. Ogle looked pretty terrible. We can just go down the list here. Did they have a little meeting and say, "Guys, this documentary makes us look pretty bad. One of us should sue. Hey, Andy, what you got going on, man?"
Isn't he also a public figure? I know he's not elected, but he is working for us, the citizens.
He is a
right?
public figure, absolutely.
So, I don't know.
Yeah, it's almost a two-pronged bag of bullshit. So you have Andy saying he never watched the documentary. So what I guess the argument he's going to make is, well, somebody came and told me they made me look this bad, so I decided to sue. Okay, well, if I wrote something bad about somebody and a friend of that somebody went and told them, hey, you'll never guess what so-and-so wrote about you, is that person not going to go read what that person wrote?
Absolutely.
Or watch what that person said? Andy's trying to make it seem like, no, that's not what I did. I didn't. They told me I looked bad, so I just immediately decided to sue. The second prong to that is, okay, so now I've hired Jax as the lawyer to sue for the defamation for me. Jax knows as a lawyer that he's going to have to prove the defamation. So wouldn't Jack go watch the documentary to see where the defamation was?
Absolutely.
Help me out here. I mean, so did the lawyers not sit down and watch the documentary and then come back to Andy and say, hey, watch this piece, watch that piece? They did none of that. How do they expect to prove their case if they don't present the actual evidence of defamation?
That's right. That's exactly right. Hey there, I want to welcome Jeff Jones. Thanks for dropping by there, big guy.
Hey, how you guys doing?
Well, we're exploring Andrew Colburn's mind a little more. What do you think? Any thoughts on that?
Yeah, I mean, I agree with the comments that were just made. Like, it's pretty dumb. It's pretty dumb. I think what they're trying to say is he didn't have to see the documentary to feel the effects of it, and I think that's why they're trying to be cheeky. But by claiming that he never actually saw it, just makes him look stupid. Like, he could be like, yeah, I saw it now after people were, I was being harassed and phone calls, and I was looking at all these posts on Facebook that said I'm the devil, and you know what I mean, like stuff like that. Like, that would make sense. But I can see where it's falling flat. Like, it's just the argument's just kind of dumb. It's just, really, no one's believing that. Like, no one is gonna buy that you haven't seen it. Anyway, but I think that's neither here nor there. I guess I was listening to his lawyer, and his lawyer just the amount of time that he spends is like 45 seconds, maybe a minute, and the other lawyers are talking for like 5 and 10 minutes apiece. And they just kind of played ping pong with him. Like, I don't know. The argument that he made seemed kind of flimsy to me, where he was saying, different defendants shouldn't get different times for depositions. But that's not what they said. They said different cases need different amounts of deposition different hours, right? And so they're kind of playing that straw man argument, like they're playing he's a victim. We're not talking about, we're talking about this case is so much bigger than a normal case that comes across your desk. We need more time. We need to probe him about all these questions. So I think it's a compelling argument to me. I don't know about you guys.
Well, the federal rule, I think, is 1 day. I think there's some kind of, subsection this, blah, 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 that typically 7 hours or a day is pretty much what the rule that they allow. And if you want or need more time, then that becomes a motion before the court. So, again, I think they were right to do it, because if they just limited it to 7 hours, or even if it was they extended it for a half hour or an hour, I still don't think that it's going to be enough time. I think a second day is called for, but I agree.
Yeah, because we don't even know what's in all the correspondence between him and convicting.
No,
so
we haven't seen everything.
There could be all kinds of stuff in there where Andy says, "No, I'm doing just fine," or maybe they paid him money. If they paid him money, his argument is now dead.
Well, and on top of that, they blocked a good portion, or virtually all of Brenda Schiller's deposition. We've only gotten just very small pieces of it. So, okay,
yeah, because I think they first have to rule on whether they're going to allow that to remain confidential, quote unquote.
Sealed. Yeah, that's right. Okay, it looks like we have roughly looks like about 9 minutes approximately left to go. So let's finish this up and hear what the judge says. I think everybody. I think he did the right thing. So here we go. I'll back it up 10 seconds, so we'll
to go further down that road, but that's just a little, I guess, of my response to that argument. Let me say this. I do think that much of the stuff that defense counsel has identified today in terms of the subject matter for deposition is likely going to be outside of this plaintiff's factual knowledge. And so while it may seem like there's a lot of stuff there to cover, I think if you focus on this being a fact witness deposition, you will likely cover it a lot quicker than you think. Deposition should not be a place to argue with the opposing party about the merits of his claims or to try to trick an individual plaintiff into making legal admissions that you try to use on summary judgment. This really should be a factual deposition. The fact that there are multiple defendants here, I'm not terribly persuaded by that. The fact that this is a significant amount of money, I certainly understand from the individual defendant's perspective, it's a lot of money. That being said, when I was in private practice, I worked on huge antitrust conspiracy cases where billions of dollars were at stake and with hundreds of transactions at issue, and still, corporate CEOs, corporate other executives would sit for 8 hours, and that was it. So the size of this case, it may seem, and I'm sure it seems significant it is significant to the parties, but in the overall scheme of things, it's not that massive a case, really. On the other hand, I will say that the complaint is lengthy and does identify a significant number of the exhibits of potential defamatory statements, which does make it hard it made it hard when I was working on the motion to dismiss to get my hands around what exactly was being alleged. And defendants have every right to go through those things and to try to identify those. To the extent and the idea that the plaintiff has not actually watched the entire documentary, then there are 2 series actually now at issue in the amended complaint. That I do think some of the allegations are factual allegations that may require setting context and asking about. I accept defense counsel's position on that. I think that's probably right. The question is how much of that is going to be required and how much of it is going to be fruitful. I also have questions in terms of whether depositions are the best form of discovery to obtain some of this information. Defense counsel have indicated that there are some inappropriate responses to requests for admission, that if the request for admission had been answered correctly, they could save some time. That's a good point. There are motions that can be brought with respect to requests for admit that are not that should have been admitted, that are not properly admitted, and I would certainly consider that, and I'd encourage the parties to try to work through those issues rather than bringing them to me. But if there is a request to admit that is foolishly or frivolously denied, I won't look kindly on that. And so I some of that's already been suggested. I don't know the full context that was beyond what was just presented in the hearing, but it doesn't sound pretty, and it doesn't sound professional. With all that being said, what I'm going to do is I'm going to deny the motion, but without prejudice. I want the parties to act professionally to get this deposition done in an efficient way, and if it's going to run over one day into two in order to get the questioning done, so be it. And I will hold Mr. Burnett to his word that if the questions are asked in good faith and the testimony continues in good faith and it requires more time, he'll give them more time. But it's a hard thing to rule on in advance because I don't know what the questions will be, and we don't know how responsive the plaintiff will be, the witness will be. Let me also make clear that to the extent that, and I don't want to accuse anybody of anything going in, but I was a litigator for 22 years, and I've had my share of witnesses where there was a time limit on a dep and the witness starts running the clock out. I won't countenance that either. So I will deny this motion without prejudice, but I will expect the plaintiffs or the defendants to ask reasonable questions, to move through as quickly as they can. And if 7 hours turns out not to be enough time to do all that, I expect plaintiff's counsel to allow additional time. You should probably reserve 2 days for this deposition just in case. But I'm not going to rule at this point. I don't think I have a record sufficient for me to conclude that this will necessarily take more than 7 hours. If it does, again, plaintiff's counsel, you should let this deposition continue until it's done. And I'll leave it at that. If there becomes a dispute, during the deposition, we can take it up. Remind me, when is this deposition scheduled for?
June 21st or July 21st, and everyone has reserved July 22nd.
Yes. I will be in the office on the 22nd, as well as on the 21st. My afternoon of the 21st is wide open. If you want, I guess what I'd ask is if I will be available on the afternoon of the 21st and on the 22nd if issues come up that you need me to address. I really hope that doesn't happen, but I will let you know that those times are available on my calendar. Again, you guys are all professional, experienced counsel, and I appreciate that there are hard feelings on both sides of this case. The plaintiff is not happy with his portrayal in this documentary. The defendants are not happy that they got sued for defamation, and rightly are concerned about the damages that apparently have been demanded in discovery, even if counsel wasn't aware of that. So I get all of that, but you guys are experienced. You should be able to work together to resolve this without further intervention of the court. But if you can't, I will be around on the afternoon of July 21st to address any issues we need to address. But again, let me strongly discourage that. I certainly don't want to invite that. Any questions?
None from the plaintiff, Your Honor.
No, Your Honor.
None. No, Your Honor.
All right. We will draft a minute order with all of this, also giving Schuler's lawyer 7 days to respond on the ceiling issue. But again, let me encourage you to work together to try to get this resolved. Because let's get discovery resolved, let's get dispositive motions filed, and let's try to get this case resolved. All right. Thank you for your time this afternoon.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Sorry about that. I should have cut that off. That's irritating as hell. Anyway, so the judge says, I'm going to give you a day. Deny the motion. I'm going to give you a day. If you need more time, I expect you to give it to him. He was, he backed that up with talking about his 22 years as a lawyer. So he understands. He knows what Netflix and these other defendants are asking for is not really unreasonable. At the same time, he doesn't have a list of questions in front of him to kind of decide in his mind, estimate time-wise. So, for himself, I think he made the correct choice. And I think, Rhonda, you made the comment that it's really a win for them. I agree. So, comments before we move forward. A lot of lively discussion in the live chat. So,
yeah, I think part of the problem they're going to have is you're expecting two groups that are in stark contrast to each other to be able to come to the same conclusions as to how did the judge put it, in good faith.
Yeah.
To give Griesbach the ability to declare anything as good faith, I think is a terrible idea. So, if they go over the 7 hours and the defense side says, hey, these are all good faith questions, and the other side says, oh, hell no, they're not, now you have a problem. Now you're going to have to call the judge because he didn't set any kind of firm limit. I like what he did, but like you mentioned before, Jax, about the indecisiveness, I think he should have made a much clearer ruling, because that door is going to be open, because that's what the plaintiff side hasn't been doing this whole time. They've been really stalling and kind of playing the game. So I can see them doing exactly that if the deposition starts to go beyond the 7 hour mark, or looks like it's going to go beyond the 7 hour mark, especially if it's substantially over the 7 hour mark.
Yeah, I don't disagree.
I think in a way that the judge has basically just told them, look, get your fucking act together. These are all adults. You should be able to get this done in a certain amount of time. And I'm going to hold the other lawyer to his word that if it ends up going over the 7 hours, then it goes over the 7 hours. So let's get this done now, whether it takes 7 hours or no. Get it done so that we can get this case finished.
Yeah.
So he's denied the how do you say it?
Denied the motion without prejudice.
Like legally, in a form of sense, legally, but basically told them, look, I'm giving you a bit of leeway, fucking grow up, get it decided, get it done, and then get back to me as soon as possible so that we can get this case cleared.
Yeah. Before I forget, Marty H, I guess, maybe joined us a little bit late, had asked earlier up on the chat, probably 5 minutes, maybe even a little bit longer ago, who's paying for this lawsuit. And as with many civil suits, these defense lawyers, they take these cases on contingency, which means if they win, they get a percentage, 30 to 40% of the winnings. If they lose, they eat it. They don't get anything. So that's how a lot of them go. We don't really know, though, in this case, if someone's paying Griesbach and these other defense lawyers. We just don't know. Any more questions before we move into we're a couple hours in, and there's something I wanted to show. It's completely separate from any of this, but I want to, I do have one more thing to show. Damn, I damn near forgot too. Good thing I
Yeah,
looked.
no, we seen you playing Jack, but the chat's just saying they can't see Netflix settling and stuff like that. Laura and Moira have fought tooth and nail for it to get as far as it's got as well. So can't see them settling. Can't see Chrome Media settling or that either, because can you imagine the doors that would open?
No way.
With all the documentaries that Netflix has got, you know what I mean? If somebody
Not just
doesn't like the
Netflix.
way it came
HBO's got
across,
HBO. HBO's got just a massive amount of documentaries on their website that they've done.
Any streaming service, period.
Absolutely.
yeah, exactly, Sapper. Yeah, you know that would open up a floodgates for everybody and anybody. And I think it was Mystic Jinx that had put in the chat. So does that mean Avery and Brendan can sue Greaseback because of the books that they've wrote and defamed them? You know what I mean?
Right.
So if it's going to work for one, it's going to work for the rest. But we know that that's just not how it works. So I can't see Netflix or Laura or that settling with Colburn at all. And
Not a
this is
chance.
going to fight to the end.
Yeah, there's no way. There's no way.
It opens up too many doors that God, this would just it would never end.
They would raise our monthly payment up to $500 a month just to cover the losses in that case.
Yeah, I'm already pissed off. They raised it $20 a month, so.
Yeah, exactly. Yeah. So I don't see it happening. I just think that the either Colburn's going to drop his case, which is not going to happen because he's already trying to save face as it is. He's going to lose his case. He's going to lose his case, and he's going to look even more ridiculous than he ever dreamed that he thinks Ma'am made him look. There's just no way he's going to win the case.
Well, and we've not even seen, the convicting and what the interview he gave there, because they did touch on a little bit about them, and we've talked about it before, them limiting his access. That he wanted to go out and do these talk shows and talk to different people about what he felt like happened to him in the documentary and in the case and so forth, and they stopped him. They didn't want him to do it, and they wanted exclusivity. Remember, we talked about that, I think, a little bit the last time we talked. We did the June 14th hearing. We talked about it. So
remember the picture from conviction where he was like crying?
Yes, that's right. That's right, Jinx. Also mentioned, and I wanted to bring this up, and I've got the document. I didn't add it to the description, but I will after we're done. I can't add it while we're live streaming, but this is document 13, and at the end of document 13 is exhibit A and B, and that Michael Vick mentioned these two exhibits, and it's talking about in the episodes these various things that were said, at least part of it. I remember looking at this document probably right after, I think it was right after this hearing, and I heard him mention it, and I went and dug around and I found it. So this is pretty early on. This is attached to the second amended complaint that Colburn filed. This is at the end. This is at the bottom. This is like page 29 of 56. There's roughly 30 pages of these two exhibits that go into these various things that were said throughout these episodes. There's episode. He goes up there, he's talking about this is talking to Glenn, one of the civil suits for Avery. There's a link. This is probably during his deposition. That's Causation. There's episode 3. So
I'm also curious to why they're not suing Stephen Glenn, who made the comment.
Yeah.
I believe part of this is that the letter or the statement that he made in 2003 was not in the safe, right? But that is what Stephen Glenn said in Ma'am. So why aren't they going after Stephen Glenn? He's the one who said it, not Netflix, not Moira, not Laura. You know, I don't understand why they're going after them when it was, you know, Stephen Glenn who had made the statement in the first place.
Right.
How is that their fault?
Well, it's just like Adam Waldman, you know, and sorry, I know everybody's tired of hearing it, but it's really the same thing with the Depp Heard trial when, you know, she ended up winning, what was it, $2 million
Yeah.
based on something that Johnny's attorney said, Adam Waldman. And so it's kind of the same concept.
It is. It really is.
Which isn't right, but, you know, it's, you know, whatever. That's what it is.
It's about the deep pockets. Steve Glenn doesn't have any money, so it'd be pointless to sue him. But what Andy and his group is trying to say is Laura and
Moira.
Yeah, they intentionally did that, and that Netflix knew they intentionally did that and aired it anyway. That's the basis of Andy's claims, is there was this intent. They knew what they were doing. They knew what they were doing was wrong, and they did it anyway. When the actual opposite of that is true. We all know that Laura and Moira had no intent whatsoever with the documentary other than filming it and putting it out there. They had no personal feelings, and if they did, they didn't put it in the documentary. And Netflix just looked at it and said, "Oh, this is great. Let's take it." And that's why he's going to lose, because there's no way they're going to be able to prove intent. There's no way.
Prove intent. Yeah, you have to be able to prove intent, and you can't get inside somebody's head like that and prove intent. Not to mention, and I always go back to this, not to mention every single person whose face was on that series was given the opportunity to be a part of it and to say what they wanted to say or dispute or refute or whatever, and the entire state side refused to have make any comments. So, you know, he had his chance. They all had their chance to dispute whatever got said, and they chose not to. So I have no sympathy. Well, first of all, just because of who they are, but secondly, because they had just the same chance that everybody else had, and they didn't want to be a part of it. So
that's right. And they could have.
You fucked yourself up over that way, then, you know. Right.
It's like crying. You know, you're crying. You know, sour grapes the day after. And I agree. I mean, this is part of it. What's on the screen now is part of Exhibit B, and you can see they've gone through here, and they said, you know, omits another line of testimony, and so on and so forth. And they're trying to say this is part of part of their plan to defame or whatever. And there's just no way. Documentarians of any stripe, there are things that you have to cut. You can't get everything in, and it not only happened, I'm sure, during this part of the documentary, whatever the episode now, whatever this came from. There are other aspects that didn't get showed, like in episode 10. I think we see Brendan with O'Kelly, you know, at the 2010 motion hearing for Brendan to appeal, and they could have done another 5 episodes just on O'Kelly and Kaczynski. There's so much material; it's terrible, but they couldn't do it. There's just no way. So, yeah. Anyway, I will add this document to the video description at the end, but I wanted to pull that up and show it. So let's get to, if there's nothing.
You're chopping up, Jack.
How about now? I'm okay now?
Yeah, I think so.
I think I was a little far away from my microphone.
Oh,
okay.
Okay, that's better.
This is document 258. 250. And I'll just read it. It's a one-page order. It's what he talked about The hearing itself is document 257. So anyway, I'll just read it out. The court heard arguments on defendant's motions to restrict a document and depose plaintiff for 14 hours. It's hereby ordered that the defendant's motion to restrict will be held under consideration to allow third party Brenda Schuler's counsel, Nicholas Kurtz, time to file a statement of good cause explaining why the documents in question should be maintained under seal. If nothing is filed by July 14th, 2022, the court will unseal the documents. Counsel for defendant Netflix Incorporated volunteered to inform Attorney Kurtz of this deadline, and the court directs her to do. It is further ordered that defendant's motion to depose a plaintiff for 14 hours is denied without prejudice. The court expects the parties to conduct depositions as expeditiously, I butchered that, as possible, quickly as possible. If the 7-hour limit proves unworkable, the court expects plaintiff's counsel to allow additional time provided that the defendants have operated in good faith. The court will resolve any further disputes as they arise. And that was July 8th, Judge Ludwig. So I think he made that. Yeah, I think that may. Say that again.
Yeah, TTM asking, and do we know if they met the deadline of the 14th?
Yeah, TTM. Someone looked, and I can't remember who it was. Someone looked at the docket, and they were still sealed. Whatever, I can't remember which one it is now. Whichever document that's under seal now, it was still sealed, and I think that was yesterday or Friday. I think it was Friday. So maybe I'll try to shoot Cherie a message, and maybe she can check sometime tomorrow when she has a minute to see if anything gets unsealed. I'd love to see it. I really would. Okay. Any more questions before I shut? I want to warn everyone, if we're good here and done, I'm going to split this because I may end up splitting this part off of the live and just creating a premiere, because this next part is a completely different case, and it involves a police department in Loveland, Colorado. And if everyone can think back a couple of years, there was a case that this woman, she's like 70 in her early 70s. She has dementia. She got out and she walked to Walmart and she took some stuff. She stole it. Well, they called the cops, and this cop chased her down. And I guess she was being resistive, and he threw her down, broke her arm, cracked her shoulder. She was damaged. He was really hard on her. The body cam footage he got in trouble. He got sent to jail. And they just settled that lawsuit, I think, last year. Paid out $3 million to that family, that woman. So this next video, or this video I'm fixing to show, let me get around here so I can get her, start getting it pulled up. I just want to warn everybody, it's rough. It's graphic. It's disturbing for anyone that hasn't watched it. There are a number, this is about a 10-minute video, and there are a number of things that there are pop-ups that get popped up in this video. Whoever put it together added a lot of information to this body cam footage. So I'll probably be pausing so anyone that wants to talk about it. There are a number of things that get said throughout and pop-ups that appear. I think even Carol may have put something in the Discord channel, one of our Discord channels, about something that was in a transcript. But anyway, what this is about, this 14-year-old girl was, I guess she was dating this 18-year-old guy, boyfriend, and she got jealous or whatever. She said that he was screwing around with this other girl. They were in a Safeway there in town, and she got mad and she slapped shit out of him and stomped off. And that was the end of the encounter. Well, someone in the store called the cops on her and reported it. They go interview the guy. You're going to see all this in the video. They go interview the guy, and basically he says, I don't want to press any charges. Let's just basically forget about it. Well, that's not what they did. And you're going to see the results of what happened. Again, I'm going to say the warning one more time. This is hard to watch. Parts of it are really difficult for me because I don't have children that young, but I've had children that young. It's difficult. So let me get this pulled over here. One second.
Just while you're getting that set up, Jack, I don't know how yous can put up with the bloody heat that yous get over there. We've got a heat wave here just now. We've got health warnings and everything going. Because we're not built here in the UK for hot temperatures. But over tomorrow, Monday and Tuesday, we're supposed to be getting up to at least 40 degrees. Well, we do it in centigrade. So, and that's bloody hot. I mean,
Yeah.
I'm sitting about 18 degrees now. And I'm sitting here with a fan. I'm sitting with a slushy. Everything to try and keep myself cool. I don't know how you bloody do it.
Yeah, it's tough, man. You get down in the southern part of the United States and Midwest and especially out west. You get into Death Valley and in those places, it's hot as hell.
Yeah, well, our houses aren't built for this type of weather, Jack. We've not got built-in air conditioning. Our houses are built to keep heat in. You know
Right.
what I mean?
It's
And like our railways and things like that, our railway tracks, the tracks buckle and swell in the heat.
oh yeah,
And everything and everything like that, and we're
happens here.
just not used to these temperatures.
Happens here too. It does. So
Yeah.
it's tough. Alrighty. Anyone here in Discord, you're going to need to unmute to watch this. So like I said, I'll be pausing this as we go. So here we go.
Truck! He just made my baby! Why did you have to shoot him? He's fine, he's a puppy! Get here! What are you fucking with me for? Stop. What are you fucking with me for?
Papers, Officer Gates regularly brags that he has one of the highest DUI arrest rates in the state.
Get on the ground! Get on the ground! Stay down, don't move! Stop! I'm not choking! I'm a canine officer, dude! Damn it! Gee.
Yeah, I saw what happened, yeah.
Would you be willing to fill out a written statement for me?
Nah.
No? Can you tell me at least?
Well, John was trying to restrain his dog, and your other officers went berserk on him, so...
Okay.
That's what I saw.
This is where we're at. You saw it there. Some of the beginning stuff are the other lawsuits and so forth that have happened in this department. But anyway, this is where we're at. After yelling at him about it in Safeway parking lot, it's going to move on. It'll tell you the rest. Now, here we go.
Well, damn it!
So what are we going to do now?
She's standing here and yelling at me about how I'm a piece of shit, how I'm cheating on her, how I cheated on her, blah, blah, blah. And I was like, I'm not even with her and I'm not with you, so it's not cheating, you know?
Well, is this something that you want to pursue and go
So would I have to go to court?
Well, you would have to completely go through a packet and fill out all your information and give a statement, and yeah, if it went that far, you would have to do that.
Alright, I think I'll just pass it off to you through the whole packet and everything.
How are we gonna...
You heard what he said. I think I'll completely pass on going through the packet. He's basically saying, no, thank you. They decided to arrest SS and charge her with assault anyway.
Head to that address, see if she's there. See if her parents are there or anyone's there.
Hey, ma'am. Are any of these their cars?
The Loveland Police Department, come to the door.
Try a couple more times.
Jack, one thing to keep in mind is, since they're declaring this a boyfriend-girlfriend situation, that's viewed as domestic, and that's a must arrest. That's not a, you don't have a choice.
Interesting. I did not know that.
If it's considered domestic then, and he's 18 and she's 14, how does that play into it?
Or does it?
Yeah.
Yeah,
It doesn't matter.
No, the age wouldn't matter in that instance.
If he's sleeping with her, would it?
They'd have to prove that, but yeah, that, I mean, if that came out from the investigation, that would be a factor, but initially with what we have now, that wouldn't be.
Yeah, they told the dad wanted her to get her outside and said they just need to talk to her. So let's move on.
Sky.
Hello.
You want to come out here, please?
He's got pizza. For DD. Actually, he's an adult. He's 18. And she's 14. That's gross.
You had the instance today where you're going to do a verbal argument over some belongings, correct? Okay. Somewhere you want to sit, or? So can you kind of tell me what happened between you guys today?
I was asking for my shit back because we got in a breakup because he likes to cheat on me for saying myself. I wanted my unicorn back, my lanyard back, my elephant back, and my bike.
Stop.
No, this is my daughter.
Put that down.
This is my daughter. She's
I
14. You
understand
can't arrest a 14-year-old. No, you cannot. No, you can't. Bullshit. Let me get my dog.
You are not going
Let me get my fucking dog.
You are not going to walk over
He's going to start fighting everybody. Let me get on the ground. Let me get on the ground. Fucking dog.
Get on the ground.
I'm not arresting shit. Fuck it. I'm not.
Get on the ground. Get on the ground. Get on the ground. Stay down. Don't move. You stay down. Don't move. If you get up, you are going to get tased again. Do you understand me? You stay down.
Getting my dog.
Roll over onto your stomach.
I was getting.
Put your hands behind your back. Put your hands behind your back. Do not move.
I won't, sir. I won't. I won't move. Stop! Stop, baby! Stop! Can you put my dog away, please?
We will take care of your dog. Put your.
Please, I don't want you guys to shoot him or anything.
We're not going to shoot your dog.
God
Knock it
damn
off.
it!
Why did you have to shoot him? He's fine, he's a puppy.
I was trying to get my dog! You guys!
You okay?
She's 14 fucking years old! This is a joke!
Yep. Hey,
This is
drop her
joke,
down.
you
Drop her
guys.
down and get on top of her. We cannot do this.
Watch your head.
He said no, but he said it's stung.
Stop. Yeah, that's about it. fast. We'll have to go through a whole packet and everything then.
Okay.
So, yeah.
Dude, just stay away from him, please. Please.
Hey, watch out.
Guys, put the dog
Dog's coming out.
If you put my dog inside, he will stop. God damn it!
Stop. I'm not choking. I'm a canine officer, dude.
Damn it!
Jeez Louise.
You're
choking my dog! Can you get your feet out of the way? Can you get your feet out of the way? Good boys. Good boys. Good boys. Get back.
My God! It's a fucking joke! No wonder why you guys get a bad rap. You fucking pushed me for no reason. I had no fucking weapons.
You are under arrest.
For what?
Obstructing and resisting
I
arrest.
obstruct nothing! I was trying to help you!
Stop.
Jesus fucking Christ!
Stop.
Get your
Roll
captain!
on your side.
Can you please get your captain?
Yeah, they're all coming, dude.
Thank you.
Chill out.
Thank you. You're being a real asshole to me.
I am?
I didn't do shit to
Look
you.
at yourself,
I was trying to get my dog. You threw me on the ground because I didn't want you guys to hurt my dog or hurt me or hurt my daughter.
Okay.
I'm not an asshole. Look at my record.
Stop.
Thank you. And you don't have to step on me like that.
I'm not stepping on you.
You just stepped on my skin.
Oh my gosh, get over yourself.
I'm not getting over myself.
Stop
Quit being so
crying.
fucking rough, man.
I'm pulling your probes out.
I
Chill out.
appreciate it.
Jesus.
Fucking A, man.
You're like a child.
Can I please get up?
No.
Oh, you're fuck.
All right, I'll pause it here for just a second. Thoughts, comments?
Now, losing my shit, losing my shit, losing my shit, losing my shit, losing my shit. Fuck, man.
That was hard.
Motherfuckers.
That was hard for me to watch the first time. I get what Sappercop's saying, and I'm really glad he's here because I wanted his perspective. I guess from just a regular person's perspective, I mean, I'm an old guy, but it escalated for really no reason. I guess from.
Let me say this.
Yeah.
Let me say this right off the bat. First of all, this is bad overall. Every cop in that video was wrong, absolutely wrong, and here's why. Not because they didn't have to make an arrest, and I'm only going on the assumption that they were treating this as if it was a domestic, and that's the only reason I say a must arrest thing. But the key thing is you are not in a rush. You don't have to get her to jail in the next 5 minutes. You've got all the time in the world you need. That's kind of the key to de-escalation. When you have somebody that's losing their mind like that, and I'm talking about the girl,
right?
Just stop. Just stop. Stop what you're doing, take a step back, and just have a conversation. Instead, they treated it like it was a violent situation, and it didn't have to be. The dad responded probably like I would respond if somebody was attacking my daughter that way. Now, I also have to say that a little bit of this is also on the girl and the father. They could have reacted differently. People who are more, I'm only judging by their living circumstances and kind of how they're dressed and how they react to kind of what their lifestyle might be like. So maybe they're used to that kind of thing. I don't know, but other people may not have reacted that same way. But that's notwithstanding, there was lots of wrong here, and most of it was on the cops. So I'll say that right from the start. There is definitely a lack of training. There's definitely an attitude issue. It should have went much differently.
Oh yeah, that one cop, I thought he was just an absolute smart ass. But I think also to add to what you're saying about their living conditions, I'm just don't live there, but I'm just wondering in the back of my mind, because there have been multiple lawsuits against that police department in recent time, if that kind of played a part to the dad, his reaction, playing in his mind. He seemed like a, relatively reasonable person, but I'm like you. I mean, most dads would react the same way as he did. But man, that one cop, he held that dog up by his neck and stuff. Canine officer. I'm thinking to myself,
I'm not joking.
Fine, officer. Jeez Louise, you motherfucker. What a dick, man. Sorry.
Yeah, he says I'm not choking it. No, you're quite clearly choking it, actually.
Absolutely.
Your mic was off. You got what you got to say, Jinx? I seen that you were on mic there.
Yep, Jinx.
I said, was there any like proof that she slapped him? Was there a mark or anything that shows that she like assaulted him? And someone actually said that she admitted to it. So I didn't quite hear that part. I must have missed it in all the screaming and stuff. So
yeah, that's part of when they muted their body cam mics. That's when she admitted to them that she did it. Plus the guy,
did she know, or was because the body cam was off, right? It was muted. How the hell do we know?
Well, that's what the video says. I don't know. Maybe.
Okay, maybe we would have to see the actual video.
Well, yeah, because I mean, assault has an element of bodily harm. So if you're looking at his face and you don't see any evidence of a slap, there's no fingerprint. No. When you slap somebody, you can see the marks of where the fingers were, depending on how long after this took place. But if there's nothing on his face that shows an evidence of a slap, people can say whatever they want. If I can't prove it, if I can't show you a picture of the guy's face that shows finger marks, I'm going on third-party word, and that's really it's kind of hard to do. So we don't get to see enough of that on the video.
It was somebody in the store. Is that right, Jack? It was somebody in the store that seen the slap happening.
Yes.
And they were the ones that phoned the police.
That's right.
And then it's escalated into this shit show, and it's absolutely fucking disgusting. And I mean, that female officer here in the UK, if there is 2 male officers that are on patrol driving about or whatever, and it is a female that they need to pull over, they will stop, they will stand there with that female, and they will call in a female officer. So is that the male officers aren't getting accused of anything inappropriate.
Right.
You know what I mean? But there was a female officer there. Why the fuck did that guy not let the female officer deal with that situation?
Yeah.
That young lassie would have probably spoke to that female officer normally without attitude or anything like that to get the story and then take it from there. And then say to the father, I'm sorry, but we're going to have to arrest her and de-escalate, not fucking escalate the situation. And that's exactly what they fuckers done. They escalated it. And it's all a power trip, especially with that other one that was talking to the father who turned around and says, you should be appreciative. What?
Yeah.
Appreciative of getting fucking tasered and his daughter battered about the place by somebody who's supposed to serve and protect. Fuck right off.
Yeah,
there would have been riots if that happened to somebody's fucking daughter.
To back up and put just a little bit more clarity, there was a little section there and it was easy to miss. I actually missed it the first time, but they looked at him and they as Sapper Cop talked about, there were no marks on him, and they asked him if it hurt, and he said, "Yeah, it stung," but there were no marks on him. So, to me, this gets into. I think that the bigger thing to me is if they had a problem, if they wanted to go talk to the dad and the daughter and say, look, this got reported as an assault, we're not going to arrest her, but we need to talk to her. And, you need to talk to your daughter and tell her, she can't do that. She's of age now. She can get in real trouble. So I think maybe that would have been the best way to handle it.
So to play devil's advocate a little bit on the male-female thing, the only time you're required, at least it was when I wore the badge, the only time you were required to have a female officer come for a female suspect or person of interest, whatever, is if they were going to be searched. If it didn't involve a search, if I just had, even if I had to go to arrest a female, I wouldn't necessarily have to have a female officer there until after I've already made the arrest. So to make the initial arrest, it doesn't have to be a same-sex officer. That's not the case. But if you're going once I had the person in cuffs and had effected the arrest, that's when I need to have a female come over because they have to conduct the physical search of the body.
Right. Yeah, that's kind of what I thought. Kind of get into what you and Alice were talking about. The other male officer was handling her, and the one that I really thought was kind of a dick. He's like, just drop her down, get on top of her. I'm like,
Yeah.
but she did slam her head, sort of get her head slammed, however you want to view it. It's not entirely clear from that viewpoint exactly how that all transpired. As I learned more, I actually did just a small amount of digging on this case, and there's more, and we'll get to that in a minute. But Rhonda?
I'm going to say there's a list. I just dropped a link in the open mic text. Each state has their own statutes regarding domestic violence. In Colorado, it does happen that they must arrest, but there was a conversation to be had first.
Yeah.
First, like you guys were just talking about, there's a conversation when you're talking about a 14-year-old child. There's a conversation to be had first before you say, I'm really sorry, but this is the statute and we're going to have to arrest you, book you, whatever. And the way they handled that was completely wrong, and their blasé, oh, we're just here doing our job attitude is wrong. There were many civil rights violations as far as I'm concerned, regardless of whether or not it's the statute.
Yeah, I agree.
For Sapper Cop.
Yeah, and that's why I said, there's no rush. The jail's still going to be there an hour from now, unless there's stuff coming across the radio that is of utmost importance. And if that's the case, I'm ditching this case anyway. I'm jumping in my car and getting out of here. We'll come back later. There's no rush, but they treated it as if they had to get it done right now. We have to get this done.
Sapper.
Yeah.
I have a question for you.
Shoot.
If he talks to this guy who's 18 years old, who's saying he's being slapped by his girlfriend who is 14. As a cop, would you then explore those questions about sex and stuff? Because he's 18, she's 14. He's admitting that they're boyfriend, girlfriend. I mean, they didn't explore any of that. Would you have? Because then it's not just a domestic violence act. It may actually be statutory rape. On the guy's
So not initially, no, because I'm going to deal with the crime that I currently have in front of me, which in this particular case was a alleged assault. So I'm going to deal with that part first. And
I'm sure when I got slapped, they asked me about our sexual relationship.
Well, yeah, because they were probably trying to establish the domestic nature. That isn't always necessary, but that is a component. So they may not. I don't know. They may not have chose to do that because of her age. If she had been older, say she had been 18 as well, maybe that's an easier question to ask. But because she is 14, maybe they just thought it a more sensitive nature and didn't go that way. I don't know.
Well, it could be a more sensitive nature if an 18-year-old is having sex with a 14-year-old, and that is against the law.
I agree, and that's why I was going to say, if in the course of investigating the assault part of it, if those questions came up and they were, she said yes they were, or he said yes they were, or whatever the case, now you've got additional stuff you can go forward with. But it wouldn't be one of the first questions I would ask. I'll put it that way.
I mean, not because, even though that's a serious crime that you're talking about, of course, that I'm with Sapper on that. That's basically at this particular point, that's a secondary thing that, that will be, or hopefully would be addressed after we take care of this slapping DV incident in a proper manner. But the way it was handled was just 100% violation, and there's just no amount of de-escalation, and lying as soon as they walk up. Oh, we just want to talk to her about a incident or whatever it was. You were a 14-year-old child. And yes, I agree. There should be some charges brought at some point against the 18-year-old, for having sex with a 14-year-old. But I agree with Sapper. That's secondary at that moment.
Yeah, that's later, Yeah, I mean, I just thought that there was no attempt to de-escalate, to handle this in a way that these domestic situations like that can always go from 0 to 9 million, just like we saw. But this was just handled so rough, And this person, I don't know who put this video together at all. My oldest son sent this to me last night. I was like, he said, "You got to watch this. You got to watch this." And I watched it. I'm like, "Oh my God, this happened actually last year." Just to clarify. So let's finish watching.
2020, actually, 2 years ago.
Yeah, I'm sorry, 2020. That's correct. I said last year. It was 2020. So let's watch. There's looks like a couple minutes left. I probably will pause it because
the other part I wanted to touch on in this is kind of where some of the responsibility falls to the dad and the daughter in this case. Like I said, the cops were completely in the wrong once it got to a certain point. But the horrible thing to say with all of this is, if you find yourself in a situation and a cop is going to arrest you, whether you don't think you did anything wrong, whether whatever the case may be, do not fight it. Just get cuffed, let them do their thing, and handle it later. Because the minute you fight back, the minute you start to struggle, you've opened the door for a use of force scenario.
Well, it changes the nature of everything.
Absolutely. And now you as the other person as the law enforcement officer should be taking a lot of things into account. Now, granted, you got a split second to make these decisions. Like, this is a 14-year-old girl. She is a female. So I'm not gonna, manhandle her like a 6'2", 200-pound male.
Right.
But I do have to keep in the back of my mind, I have no idea what this girl's capable of. I don't know if she's a, black belt in jiu-jitsu. I don't know if she's, they never checked her for weapons. So, and you notice when she first came out, she had her hands in her pockets, right? That's a big no-no right from the start. So right. I don't know if she's got weapons on her. All of these things are coming into play as I'm putting my hands on her to do, what I'm supposed to be doing to cuff her. So
when a cop walks up to your house and asks you to come out to talk to you, you shouldn't have your hands in your pockets. For some reason, that's a threat to them. She was a 14-year-old girl.
Yeah, but they,
and slapped a boyfriend.
And
she used a gun on him. She didn't have a weapon. Her weapon was her hand. So I guess in that regard, her weapons were in her pockets.
But
they don't know that.
She came out of her house, and her hands were already in her pockets when she came out. So I've got no idea what she has in her pockets.
Yeah,
and
they can't.
I didn't hear them.
But they didn't tell her they were there to arrest her, put your hands up, come out of the house. They're like, we just want to talk to you. So when a cop just wants to talk to you, you still have to be like, how did she know she was in any trouble or anything that she would feel like they felt threatened? I mean, how does it? I don't know how that works.
So that comes down to the adage of you want to be able to set your own battlefield. All right, that's the way I'll phrase that. So if I know I'm going to arrest someone, I don't want them to know ahead of time that I'm going to arrest them, right? Because the arrest has to be somewhat of a surprise. That way I can mitigate any adverse reaction, right? So if you don't want to be arrested and I tell you I'm coming to arrest you, I'm already kind of leaving open the door for you to fight me before I even get my hands on you. But if you have no idea that you're going to be going to jail, but I do, and I've chosen, or I have developed the area in which I'm going to make that happen, I've made sure that the advantage is on my side, and that's what I want. And that's actually best for both the officer and whoever the other person is, right? Because the last thing we actually want is any kind of physical confrontation.
Correct.
So if I'm going to arrest you and I can make that happen without your knowledge, that helps both of us. I know that sounds funny, but that's kind of the idea.
Yeah, no, I get what you're saying. And there's another thing too. In some states, I think unless they have a warrant in hand, I don't think that they can actually go inside someone's house and arrest them.
No, that's only on a felony.
Right.
That's only on a felony.
So they really needed her to come outside to do that.
Yeah.
And that
Thompson
situation
says it's his 14-year-old daughter. You have some rights as an adult here in Australia. All questions of a 14-year-old must be done through an attorney or a parent. So for them to come over and not ask to talk to the parent first, should that be something that's changed?
They did talk to her. They did talk to her first, or talk to him first, and he got her outside.
Yeah. I was about to say in that
they
scenario,
said we're just here to talk to her.
Well, again, like I said, they're putting the advantage on their side. So
yes.
I
would
that
do that
cops
too.
lie in that way. I mean, had he walked up to the guy and said, "We need to arrest your daughter for domestic violence. Can you bring her out?" Or it might have gone a lot. That's also de-escalating when you're lying to them. Oh, we're just here to talk to your daughter, and then they start grabbing her and trying to put her in handcuffs to a father. That's kind of fucked up.
Well, that's already you've already started the escalation. You've already started the escalation right there, right off the bat. I mean, to me, that's just an opinion.
In my opinion, you do.
Well, two things. If they approach and they talk to the dad and they said, "Okay, we're going to have to arrest your daughter. Can you go bring her out?" And the dad says, "No, fuck you. Well, you're kind of stuck now. What do you do?"
And don't you have to go? He would have to go get a warrant for her arrest because she. I mean, wouldn't that be what you would do? I mean, if she ran or whatever. Or, I mean, how does that work?
Would come out.
Yeah, I mean, they've at that point, based on, again, assuming assuming they were approaching this as a domestic situation,
right.
They already have the probable cause, so they don't need a warrant. But because of the nature
let me ask you this. Had they not been home and she took off, what would have happened if they couldn't find her?
Bench warrant?
And they just have to wait for another day. Yeah.
Don't you put out your little APB warrant for arrest for so-and-so, and she's in some system now that if they catch her in another county, she has a warrant for an abuse?
There's a couple of different ways you can do it. You know, you could go do an actual bench warrant, or you could just get put it out in the in the
APB.
Call it an APB. They don't really call it that, but
right.
You put it out that you've got probable cause for an arrest for this person.
An attempt to locate or something of that nature. ATL, whatever.
Here are my thoughts. Given just what we were able to see on the video with no other information, my thoughts are you walk up to the father and you say, or you bang down the doors and the windows, whatever else they did. Then the dad says, "I live here. What do you do? You know, what's up? We're looking for so-and-so. We need to question her regarding a possible domestic violence or a possible assault or whatever." There was many different ways for the police to approach that.
That's right.
Absolutely. And I get last minute thoughts, but they had been looking for this girl all day, according to the video, what we were able to see. So there was a much different way that they could have addressed the whole thing to start with, than to, like what Jinx said, then just to say, "Oh, we're just here to talk to your daughter." So he's thinking clearly he is not concerned that it's something serious, because he went back to working on the bike or whatever it was he was working on.
That's right.
Hey, get out here. The cops are here. They want to talk to you. And maybe she did have other run-ins with law enforcement. We don't know that. But even if that was the case, they could have, I'm sorry, they had all day long to rehearse and to plan ahead how they were going to approach the family in general when they found this girl.
Well, I
And
think
that
that's,
the
I
way
think, I think this is part of
jumped
their,
up,
I think this is part, I'm sorry to interrupt, but I just think that that's part of the issue and the problems they've had in that county, because as we saw earlier on, and it went through it pretty quickly, but they've had a number of pretty high profile lawsuits in that county. And there's going to be some things said
yeah.
coming up in this video that just blew my mind. But yeah, go ahead.
And also, I don't know about Loveland specifically, but I also know that over time there has been big problems in the state of Colorado in general where body cams are being shut off. And we saw it in this video, perfect example in this video. Audio is being cut off or video is being cut off and then turned back on. And there needs to be some sort of thing where that is not allowed, or you face some sort of repercussions on the department.
I have to agree. It can't be a if I want to kind of situation. If they're going to the bathroom,
No, and
it's different.
Yeah, it's not supposed to be. You are not supposed to manipulate your cams. You turn it on when a scenario, when you're getting out of your car, whatever the case may be, you turn it on, and that's it. You let it run until you're completely done, moving on to your next thing. But to go and turn off sound or turn it off while you're in the middle of something, yeah, you're not supposed to be able to do that.
Right.
So I don't know how they got away with that part of it. That was completely wrong. Crockett said something about didn't the boyfriend say no? When it comes to a domestic situation, it doesn't matter what the victim says.
State takes over at that point.
Yeah,
It's
a lot of
What?
it
What makes
typically
it
becomes a must
domestic?
arrest. Any type of boyfriend, girlfriend, husband, wife,
You're not
brother,
living
sister.
together. It doesn't sound like.
They don't know that though.
Partners though.
But if he's an 18-year-old guy living with a 14-year-old, that's a problem too.
Don't disagree.
Yeah, but that's not what they're there to talk about or investigate at that point. They don't necessarily even know that maybe at that point. Possibly.
Yeah, so there's a lot of things about this that we
we'll
don't
just
know.
ignore one crime for another crime. Maybe there
No,
was.
I don't.
I mean, at that point, like you said earlier, that maybe it was too sensitive a subject. Why didn't they ask the guy who was 18?
Don't
if
know.
It was a sexual relationship.
Do
people investigate anything anymore? Do they ask questions that are just like, "Oh, she slapped me, it stung. Okay, let's go arrest her." That's what happened.
Well,
here.
hold on. Now here's a problem I talk about with the media all the time. We didn't see the whole interaction with the guy. They could have had a 2-hour conversation with him. We don't know. So
yeah, that's true.
Well,
so that's why I was going to say we don't know.
Footage, because now I got to see that.
Right. And the other part of that is we also don't know what either of these people's history has been with law enforcement in the past. So if this girl has a laundry list of law enforcement contact, that's going to change how you approach it, things like that. So there's just a lot we don't know. We're going off of a lot of edited footage,
snippets of time.
Yeah, we have to make a lot of assumptions on certain things.
Yeah, I mean that's fair enough, Stapper. Yeah, we're only getting certain edited bits. That's fair enough. But I'm sorry for somebody who's on the outside looking in. There is a serious problem with your cops in America. They're too gung-ho. They're too pull the trigger first and then ask questions later.
Well, that's part of the training. That's what that we want it. A lot of it we want it reformed, and it's not that we're against police.
Yeah,
we're not. We're not at all.
Yeah, but the thing is, though, Jack. I mean, your cops go for a few months training. And then they're cops.
Not in some cases. It's far less than that.
Well, when you go through the academy, depending on where you're at, if you're going to like some like LAPD, for example, or LA Sheriff's Office, you're going through a 6-month academy.
Yes.
And then once you're done with the academy, you're going to spend over a year on what they call FTO or FTEP. It's basic training probation. So you're going to spend the first year.
They're a boot.
Yeah, you're going to spend the first year basically getting your ass handed to you by your training crew. You're going to be you're going to be doing your normal shift, and then either before or even sometimes before and after your normal shift, you're going to go through other training. You're going to go through scenario training. You're going to go through hand-to-hand training. You're going to it's not a fun first year, I'll tell you that. Then after that,
here in the UK, Sapper, rookie cops have to do 2 years before they're even put into a police station, and then they're the rookie, and they go through the kind of things that you're saying, on the job training and everything like that. But it takes them 2 years to get there. You know what I mean? So they're doing all that training, and any new things that come out, like fucking rules or anything like that they've got to follow or anything like that, they come out, they get put in that 2 years that they're doing their training, but they're also still doing training after that 2 years. You know what I mean? You can't just go to I don't think it's the academy here, maybe it is the police academy, but you don't just go there for 6 months and then that's it, you're in Lothian and Borders Police.
Well,
and going about and arresting people and everything like that. They get 2 years of training, and then they're put with an experienced officer, and that officer takes them round and shows them the ropes, basically.
I'm going to
But
tell
they
you
get a hell of a lot more training.
I'm going to tell you right now, in some counties, some small counties, if you're 18, don't have a record, you could definitely get hired in very short order with little training. I'm telling you, that's fact.
You've got to have a clean record. You can't have a criminal record or anything like that. Right. To join your police forces, they get 2 years training, and then they're on the job, and then they're still doing training after that, because you know yourself, there's always new laws or new rules or anything like that comes out. And if you go on YouTube or whatever and look at riots that happen in the UK, at the beginning, for big crowds and things like that, big protests and things like that, our coppers aren't covered from head to toe in armour. You know what I mean? They've not got helmets, tasers, batons, guns, shields, or anything like that. They've got a fluorescent yellow jacket on and their bobby hat, and that's it. And they're trained to de-escalate first. And then I think, if I remember right, they've got their gear in their vans and in their motors, like their shields and everything like that, in case anything does happen. But even at that, we don't go in all guns blazing and shoot people. Well, we don't have guns in our streets. There's specific units that have got guns. And they get called out if there's a scenario like that with shootings and everything like that. But our normal bobbies on the beat do not earn head to toe in riot gear. You know what I mean? And they de-escalate.
Well, I think that's the the whole key of what this caught my eye is the attempt to de-escalate, to keep this. It's going to be an upsetting situation anyway, but to keep it de-escalated as much as possible. And then to add to the whole mix of all this, he's got his little dogs out there that I guess they're protective. I won't say that they're necessarily aggressive, because they were walking around everyone when it first started. So they weren't really aggressive dogs, but certainly protective. So anyway, yeah.
So a couple of points I'll touch is, you can only train so much. There is no way to train for every scenario you're going to encounter. At some point, you have to learn by doing. So you have to, the training equips you with really kind of the basic knowledge of, the all the specific criminal codes, vehicle codes, basic patrolling skills, driving, all that. You can train that, ad nauseum. But when it comes to a specific scenarios, there's too many variables. You'll never be able to touch them all. So you go the best you can, and then you have to let that person out and start doing. But you're going to be with another officer, your training officer, for the first year. After even after your normal department training level, you're still going to be with that other officer, and that's typically an experienced officer, somebody who's got, probably more than 6 years on the force.
Right.
They've got their own special training, things like that. So
How about policies?
you can only train so far. And then the other part about, like you were talking about with riot gear and riots, I am not going out into the area of a protest or a riot in just a vest and a bat. You better give me some gear, because once it turns ugly, it's too late to go get your stuff then, because you're going to be rushed. You're gonna be surrounded. You're not a protester's not going to stand back and give you time to put all your gear on. They're gonna start whooping on you. So if I know there's going to be a protest, if there's a massive group of people that are already at an elevated emotional state, I'm going out equipped, because I'm going home at the end of the night.
Also, and I think that maybe you can comment on this or not, but domestic situations are the worst. The worst.
Absolutely.
To deal with, because you never know, and people can get really upset sometimes when they really shouldn't. But certainly they can overreact. Everybody overreacts. I'm not just going to blame one side or the other, because it's so elevated. This situation here,
Human nature. It's human nature.
Yeah, but
Jack,
Yeah,
that's
too.
the point. That's
Yeah.
the point where law enforcement is trained to de-escalate. And if we can't count on our law enforcement to de-escalate, and I don't mean blanket, I don't mean everyone or every law enforcement officer. I don't mean that, but we see examples of it nearly every single day in the news where they don't de-escalate. They just jump in and go off of a thing they saw or a thing they heard or whatever, and that's it. And that's where I think a lot of the problems is lack of training, possibly. Although I believe they're trained, I'm not saying that they're not properly trained or even halfway trained, but that's part of law. I mean, I only had 2 semesters in college regarding law enforcement and things like that when I considered going through post. But that was like one of our number one things that we would talk about, and extensively, is de-escalation, and how many of these violent things that we see on the TVs every fucking day can be avoided completely if a law enforcement officer involved in a situation would do their very best to de-escalate first. And I'm not talking about where a weapon is being brandished or anything like that. I'm talking about this situation that we just watched. I get it. She came out of her house with her hands in her pockets. She thought she was just going to be talked to. Did they say to her when she walked to the door, take your hands out of your pockets? I didn't hear that.
No, they didn't. We didn't hear it. Did they? Yeah.
We didn't hear it. It could have been edited out. But like I said in the very beginning, because this is all that we had to go on with this particular situation, they didn't even start out by trying to de-escalate, even considering that they could have. This is my perception of it, and I don't care if it's offensive to anybody, but my perception is they walked up, we're the fucking cops, and we're here to talk to your daughter, and so get her out here. And then I'm the cops, so you get out here and we're going to arrest you and take you to jail. What for? Well, we'll tell you that later. And by the way, we're going to choke your fucking dog and tase your dad to the ground and push him around like he's not important either. I'm really heated about this. It's really got me pissed off.
Well,
and I don't
that's
think
why
it
I
was
said
handled at
no.
all correctly.
I don't either. That's
Sorry.
why. No, you're fine. I mean, it was disturbing. You know, and I watched it 2 or 3 times, and it's been just as disturbing to me each and every time. I've caught a little bit more snippets here and there, but I just felt like it was. Sapricop said there were just a ton of mistakes made at the very beginning. It should have been handled differently. So we've had
and that's why.
For a while.
I'm sorry. I was just reading. They say the policy for Loveland Police Department is not to arrest anyone 14 and under unless it's a very dangerous crime or a dangerous felony. So is domestic violence considered a dangerous felony?
Maybe that's a judgment call. Sapper, what do you think?
Yeah, the problem you have there.
He got slapped and it caused no pain. It stung. Is that a dangerous felony?
Well, again, the problem is a department policy will not supersede state law. So if the state law says in a domestic situation, thou shalt arrest, I don't care what your department policy says, you will arrest. You can't change. You can't, circumvent state law because you don't want your own department policy to, follow along. You can't do that.
Right.
You can add to, but can't take away.
Can't supersede, yeah.
I'm arresting her. Arrest her. Do what you have to do. Arrest her. But they could have started out a much more calm, civil way than what they did. And if arrest her, do what you have to do if that's what following the law is, or following the state law versus your local laws or whatever. Do what you have to do. Follow those laws and policies. But you need to start out in a much calmer, de-escalation way when you start out, not the way they did it.
I think they could have. I think they could have just said, told the dad, the situation. So look, we're going to have to arrest your daughter because she's broken the law, and we have no choice in this. We want to handle this the right way. Can you please get her to come out? We'll talk to her, and we're going to have to go through this process. In the story, I wouldn't like it,
and that's why.
Go ahead, Sam.
I was saying, and that's why I said from the very beginning that, from my perspective, nothing about this video went the right way. Nothing.
Yeah.
The cops were absolutely in the wrong. I don't know if I'll say from start to finish because when they first got there, everything seemed okay, but once they reached the point where the girl started to get upset and the dad started to get upset, that's when the de-escalation should have started. Instead, they escalated. They went upwards along with the girl and the dad, and that's the wrong way to go. And As soon as that happened, it was a shit show. So, yeah, the two most dangerous situations for a law enforcement officer are traffic stops and domestic calls.
Absolutely. I read too many stories about cops going to serve a warrant or whatever to a house. Bam, they don't even get to the door and they get shot. Just get fucking shot.
Yeah.
And I do that. I can't tell you how I hate that. I absolutely hate it because you got a cop, good, bad, or indifferent. He's just doing his job by going to serve this warrant or whatever, and they don't have a chance. And I hate that. Anyway, all right, we got a couple of minutes.
Yeah,
Go ahead.
I was gonna say, it sounds like Loveland is an exception in the fact that they've got a whole bunch of this type of stuff happening there. But you also have to keep in mind that for every one incident we hear about in the news of something going dreadfully wrong, there's probably 1,000 scenarios where everything went right that you're never going to hear about.
Correct.
So keep that in the back of your head. The media only wants us to see the worst of the worst, and that's what they want us to form our opinions off of.
Yeah,
I get
agree.
that. That's why I said I'm not giving a blanket statement for all law enforcement officers. But you know what? I want to see good stuff. I want to see the good, feel good, warm story. But when I
but good doesn't sell. Good doesn't bring media money.
I understand, and I don't give a shit about the fucking money. I'm like, it doesn't make, I get that. That's their job. That's what they do. Trust me, I am all about hating on the MSM because I think they're shitty. I think it's a horrible gig that they have. But I don't care if there's a million wonderful feel-good stories going on behind the scenes and all I see is the one. I don't want to see the one. I don't want to ever see the fucking one.
Right.
And that's why I get so pissed.
Right.
Yeah, well, I agree. I'm the same way. I hate when I see these types of things happen, especially in this kind of case where, all indications are law enforcement was in the wrong. The other thing we also have to keep in mind is, again, with our lovely media, is even when they show us the worst thing, they only show us their version of the worst thing. So there's other stuff that has already happened.
That's right.
That factored into this thing happening that they never tell us about. We only find out later after the shit has already hit the fan. The whole what's that idiot's name? Rodney King. The only thing they showed you was the video of the cops beating him. They didn't talk about what happened all day long before they got to that point. And that's why I hate our media. They
well tell
only
me,
feed us what they want
tell
to
me
feed
what
us.
happened all day long, unless it was absolutely pertained to that particular situation.
Most people don't know that he was hopped up on PCP number one. He was hopped up on PCP number one. That's a big problem. I don't know if you've ever encountered.
Did it have anything to do though with what happened in that situation?
Well, I wasn't done.
All day long.
So he was hopped up on PCP, and I can tell you from having dealt with somebody on PCP, they don't feel pain. There's no pain tolerance. There's none of that going on. So
drug PCP stuff too. I know. I've studied it as well.
And he had already led them on, I believe it was a several hours long, 90-mile-an-hour plus car chase through neighborhoods. So he already showed that he had no value for anybody else's life at that point. So once you've reached the point where he's done that and you have a situation where you've got this person that is not going to feel anything you're trying to do to him, the gloves come off, and you just don't have any way around it. Now they took it a little far, but
they lost control.
They left out all they never told anybody about that he was on drugs, that he had been on this chase through neighborhoods and all that. They left all of that out. They only showed you the video, and that's what the media does. They take little bits and pieces that they want us to have, and they feed it to us with a huge spoon, and keep back all the mitigating factors that would have been, possibly in law enforcement's favor. That's the only point I'm trying to make. Again, I'm also not saying that the Rodney King beating was condoned and that was the right thing. There was just other stuff that went into it that got it to that point.
Well, there's another thing here too that we're kind of talking around it, but here to me is what it also another effect that it has. Even only seeing the bad videos that where they get popped up in the media is the difficulty for the officer that will de-escalate, because the next person in Loveland says, if a situation arises where the cops are coming, they're going to have to arrest someone. They think about this situation instead of this regular officer coming out to do his job. Normally, he's there to keep everything calm. He can't. He's already fucked, right? He's already screwed.
Yeah.
So it makes it really difficult. It's such a
now you already have people that are conditioned to believe that the cops are out to get you. And I know what you're saying, Rhonda. You don't mean it that way, but they're putting this condition in our minds that cops are the bad guys. And so if anytime you're gonna encounter a cop, you better be right on top of your game. You better, and all of this. And that's they're putting both parties in bad situations now.
They are, and it's unfair, and I hate it too. I get it, and I think as a person that I worked, I was busy for so long, I just ate what the media told me. I didn't realize all the bullshit that was going on. Man, when I woke up, I was mad, and it still makes me mad. We still see things every day that we know that there's far more to the story than what just got reported. And thinking to myself, why aren't you telling the rest of the story? You may not like it, or it may kind of go against what you think should have happened, but show everything and let everyone make their own mind up. Don't do this snippets of time. It's so unfair, man. It's wrong.
Yeah, but it's not even just that. I mean, as an outsider looking in, right? All I see, excuse me, all I see, and I wish it wasn't that way, but it is. All I see is cops being gung-ho with no thoughts, no consideration, no nothing. I mean, a prime example is the young soldier who got pulled over in the garage. The way the cops were speaking to him, he was in his bloody army uniform and everything. And all he was asking was, what did I do? I'm not getting out of my car. What did I do? And he's getting threatened, he's getting shot. They've already pulled their guns. Fucking everything. And that's all I ever seem to see is cops, no matter what state it is, it's all across America. It's not just in one certain state. It's the cops being fucking gung-ho and pulling people over left, right and centre without, you know, I mean, the guy had his hands up and everything and they still tased him and everything like that. And to me, that's just not how policing should be. And yeah, I know people like that with traffic stops and everything like that, you've got to take into consideration that that person could have a gun in the car and everything like that. I do understand that. But the majority of the ones that I see, the person in the car or who's been pulled over or the fucking 14-year-old who got shot in the back, you know what I mean? There is just no need for it. There is too many cops out there that are gung-ho with their fucking weapons and think that they're on a fucking power trip because they're a police officer and everything like that. And I'm sorry, but it's they ones that give all the rest of them a bad name. As the saying goes, it only takes one apple to spoil the barrel. You know what I mean? And there is probably hundreds and thousands of cops all over America that are good at what they do. Try and de-escalate.
Absolutely.
And everything like that. I'm not saying every one of them is corrupt and fucking biased and everything like that.
That's what we're talking about.
As an outsider looking into your country, that's all I see.
It's the snippets that Sapper and even Rhonda were talking about. They're pulling out the worst of the worst and not showing so much of the other hard work that regular officers, they're just like us. You know, they're just a person who's going to do their job the best they can. And it really makes it really unfair. Yes, bad policing needs to change. It needs to stop.
It does. It does make it unfair, Jack. It really does, because there is. I mean, there was one that I seen when the riots and that were going on, the protests, no riots, protests and that were going on when George Floyd got killed. There was a sheriff, I can't even remember what county or that he was, and he went out to the protesters and he's like, look, I'm not wanting to move you on or anything like that. He's like, what do you want from me? I'm the person that's in charge here. What would you like from me? And they said, march with us, show that you're with us and that you're that you're against this violence. And he went, right, okay, come on then, let's march. And we'll go down here and we'll march. And I thought, wow, if all the fucking cops in America had the same attitude as that guy, there wouldn't be as many shootings and fucking everything like that. And it's a shame that cops like him are getting put to the back because of the cops. And everybody's got phones in that now. And I mean, this is just my opinion, but I think the cops are only pissed off. The way that they're pissed off is because they're getting caught for it now.
Well,
because
some of them,
everybody's got
some
a
of them,
camera.
some of them for
Everybody's
sure.
full of it.
Yeah, some of them
You
for
know what I
sure.
mean?
They're not very good at their
Yeah,
job.
and
They're
they
not
don't
trained.
like it.
They're not trained properly. They're used to
Yeah, not even that they're
being
not trained properly, Jack. The fact that they've been doing this for years, the way they've arrested people and being
that's right.
forceful and everything like that. You know what I mean? The way they're arresting them, the way they're approaching them, and everything like that. They've been doing that for years and they've got away with it. Well, now they can't really get away with it because everybody's got a camera. So when they're getting stopped or whatever, they're turning on their camera and everything like that. And I mean, I'm sure I've heard somebody say, I don't know who it was, but I've heard somebody say that there's an actual app that you guys have got in America that you can say, is it Siri or Alexa or something like that, and being pulled over, and then it starts recording automatically while you're in that stop. I mean, to even have something like that, or need to have something like that, I think is shocking. You know what I mean? Because you shouldn't have to switch on something like that to record the police in case the police are being fucking out of order.
Well, I think that escalation, and I wasn't part of the policing, but just from what I kind of noticed again, this is what's reported. It seems like that since probably the early 90s, that de-escalation that training became far less. We don't have nearly as much of it. I don't know that for a fact. Maybe Sapper can comment on that. That's just what I observed. I don't know that that's true, but it seems like in many of these situations like this one where we watched, that it's not really part of their training. It escalated just like bam, man. It was like holy shit. So
I can tell you from my academy experience that they created scenarios specifically to put you in a situation where you had the option to escalate or de-escalate, and they wanted to see which option you were going to take. And there was many times when they were looking specifically for a de-escalation technique, and if you didn't apply it, you didn't use it, you didn't take that option, you failed. Man, we did a whole bunch of that kind of stuff, both in the academy and with the department when I was actually with the department. But they'll also put you into situations where they give you a scenario that seems completely normal, completely innocuous, no red flags or nothing, and then they hit you with it. So I personally had all kinds of training that was focused specifically on judging my ability to de-escalate.
So this is kind of a psychological test for y'all, and they see which way see which way you're going to turn. That's good.
Yep.
I mean, sound like you were led down the correct way, and it gave you options. Right. Yeah, that's good.
Yep.
Okay. All right. Let's play this last couple minutes, and I don't know how much we may have some more conversation because there's some things that get said, not necessarily about the police. There are people within the city council. You're going to hear it. Anyway, let's play it. Let's get back to it. Let me blow this up again here. All right, here we go.
I think the amount of attack that have been launched against them without information, without full disclosure of information, is really unjust.
Councilman Don Overcash says each controversial incident is independent, and he doesn't see a pattern of issues.
It's tragic when someone is harmed physically in any way, shape, or form. It would have been even more tragic if that officer hadn't been able to get home that night to his family. Please don't speak about what you don't know about, citizen.
A lot of the things that our force is doing are basically, they are following best practices.
As their employers, as their city council, as their support, okay? I support them 365, even when they make a mistake. And I don't expect any single one of them to ever be perfect, and this kind of an action on the part of counsel.
Hold that for a second. I'm sure everyone just saw that officer punching and kicking whoever's on the ground, and there's like 8 of them around him. I want to make mention of that.
Steps up and says that we're with them, we're behind them, 365, 24/7, and that's where I'll always be. Thank you.
There you go. So I got one more page to show you here. So this was happened in 2020.
It takes 6 police motors.
Yeah, there was 5 or 6 cars out there. I noticed that. That's pretty crazy.
You know what I mean? I just counted them there, Jack, and there was fucking 6 police motors that turned up for a fucking 14-year-old.
Yeah.
Well, so that's the danger when you've let something escalate into something it never should have been.
Everybody gets
those
everyone gets
cops
caught.
aren't showing up. Yeah, those cops aren't showing up because there's a 14-year-old being arrested. Those cops are showing up because the call has gone out that there's cops in a fight. That's what they're showing up for.
Yeah. So this family sued the police department. I actually have not read deep into this. I caught this earlier before we went live, and I really haven't read too much. I just saw that they did sue them. I haven't read the lawsuit or anything of that nature. And actually, this video is embedded. This video here may be just a straight body cam. I don't know. I have not watched it. I will also leave a link to this webpage in the video description for anybody that wants to go back and watch it.
All right. Yeah. See, right there it says LPD officers went to the girl's home for what the city said was a statutorily mandated arrest. So they were treating it, or they were approaching it as a domestic situation.
Yeah. Yeah. So
doesn't mean you're right. I'm just saying that's why it started as an arrest instead of a talking.
Right. Right. So anyway, I just felt like that, this would be an interesting subject to talk about. Knowing where a lot of us stand on these various issues of, especially, with the Avery Dassey cases and what we, kind of know about what's transpired there, which has been just rough as hell. I did want to make mention also, KZ put out a tweet. I think it was yesterday, actually. I don't know if you guys saw that or not. Let me see if I can pull that up here. Where the hell's that at? I think I can find it here on TikTok. Because I tweeted it on TikTok. Yeah, here we go. Just a second.
I agree, Rhonda. It was not handled properly. I said that from the start. And Crockett, when the other officers that started showing up, they're only getting the last information, and that is that cops are in a fight. They don't know who they're in a fight with. They probably don't know that. They just get that call and they're showing up. Because if your buddy is in contact and you're not being told who they're in contact with, you're going to show up.
Yeah.
That's just how that works.
So Zellner tweeted out to all the naysayers who think we have forgotten Stephen Avery, do something useful and positive. It keeps your brain active and puts a smile on your face. Meanwhile, we're doing something useful, completing his new petition with compelling new evidence, and we're smiling. Truth wins. So I thought that was an interesting tweet that she put out. As many know, Zellner's been involved in another murder case, wrongful conviction kind of thing, and that actually just got wrapped up, I think, at the end of last week. I think that's right. So she's been involved in that. Not that she's not working on Stephen's case. So I would imagine, I think that I don't know that this is for sure. I think that they're waiting on the decisions due here in a week or two in that case. It's unclear if she'll file the petition for this new petition on Avery's case prior to that. I kind of have a feeling she won't, but she's not necessarily dealing with possible two major things at one time. There's and always considering the news cycle and what's happening there. I'm sure she wants to try to hit it where she can get attention, which is her. That's part of her job. So we'll see.
What do you think? What do you think the compelling evidence might be?
That's a good question.
I don't know. I honestly don't know. And I'm just thinking to myself, if whatever she's doing here at the state level doesn't work, if this is the route she's going, will she? And it doesn't work. Will she go federal? Is that there's all kinds of scenarios. I have no idea, man. I just don't know.
Those calls have been released, right, with the timestamps on there. Is there anything she can do with that stuff? Are there any extra calls that were relevant that might be considered a Brady violation? Not giving the timestamps, and did the defense have all of the calls that were released by Rookie in the past? What was it? 6 weeks ago, 8 weeks ago?
Yeah, that was back in April, March or April, I think. Yeah, I mean, a lot of the calls are, we can only narrow it down to, like an hour or I mean, it's a time frame and not a time stamp. So
yeah, but even that was not given to the defense. They got track 1, track 2, track 3. And did they get all the tracks? How many tracks were on that first? Weren't there a lot more calls than what was originally released?
Oh yeah, absolutely. I mean, Rookie got the original 13 13 CDs, and then when the new guy Cummings got, when LeBron left, and then Cummings got on the case, he asked again, and suddenly there's 35 CDs. Two of those.
Some of them are interesting because I know I think we had the call, the radio call where he asks Colburn, did you call in those plates yet? But I remember Rookie did a post on that, and he had to kind of go off the times at when Deirdre is actually calling CASO dispatch, which was on CSO's on 9/17. But in Manitowoc's end, that call got a timestamp on it for 9:21 p.m. and at 9:22 p.m., which would have been track 3 on the defense's thing, was Colburn calling in the plates 1 minute later. They didn't have that information back then. Could that be considered a Brady violation? Could that prove that,
something got withheld?
Yeah, but the question there is going to be, is the content of that call going to change the outcome of the trial? And
does it change the content of the trial if they're asking him to call in a plate and 1 minute later he's calling in plates for Teresa? It kind of gives more light on what actually happened. That oh, I just did it because I was checking my notes. No, you weren't. Somebody asked you to call in a plate 1 minute earlier.
Yeah, I don't know. And another question, I think, Sapper, everybody, would it be procedurally barred?
How could it be procedurally barred if it just came up now?
If they just found out something now, yeah, I guess it couldn't because the clock doesn't start, I guess, until you have.
They
I
have
think
to
12,
file
12 months.
a new appeal.
Yeah, I mean,
They
I
need
think
new
you have.
evidence for that.
I think you have 12 months. Once a lawyer finds something out, I think that's right.
Okay, so and if it just found out in April or May or March or whenever they were released, it's only been what, 4 months?
Yeah, I don't know. I don't know what she's got. It's I don't know, but
I'm so curious.
Well, I'm
That's
just
all I know.
well, I'm just looking at the case overall. This road we've traveled from way back when she first started filing. Everything's pretty much relatively been denied, and whatever comes up this time, is it strong enough that it grants whatever the next step may be? What I'm not even say a hearing, an evidentiary hearing, whatever that next step is, or if it's not, it gets denied. What's after that? What is left? Which route? So I don't know, man. I don't know.
That's just my thoughts. Could it be something like that? I don't know if it would be like strong, compelling evidence, but then again, some of the stuff she said, she had strong, compelling evidence, and in my opinion, it really was lacking. Like the Lewinsky stuff, the Ramlau stuff.
The
Denise Coakley call. Like some of that stuff I found lacking.
Yeah, it would need to be completely new evidence, though, would it no? Because there's that much that's been procedurally say it again, Alice. That word barred. So for it to put something out like that, I mean, like she did this before. Remember that she put something out, and we were all exactly in the same position. Like Jinx, our nose was bothering us. We were curious. We're interested, but it would need to be something completely new and no found before.
Yeah, or something that's or something that's known, but there was evidence that pertains to that just became known. Something that she could add to.
How about some of those calls were people calling in and we don't know the numbers and we don't know where the call went after I have some information that they might like on the missing girl, and they were supposed to be directing them to Calumet, but some of those calls, well, let me transfer you to this person, and it made it through to another person, but you don't hear the other end of that call. Is there a possibility that she could have played those for Sowinski, and one of those calls was actually Sowinski, and we don't know what the rest of the conversation is because all we hear is, "Can I speak with somebody about the missing person?" And then it was transferred.
Correct. Yeah, that's possible. There's definitely a possibility there. It is irritating with so many of the calls from, especially from Manitowoc. I mean, there are some. Yeah, we have the time. The stamp is correct, but there are hundreds of others that we have a track 1, track 2, track 3, or it's a range of calls, or 20 tracks or 40 tracks within a time period. It really makes it so difficult to know when a call was made. So I don't know, man. I'm just.
But we would know, like he says he calls the 5th, right? So even if those calls had come in between 5 a.m. and 8 a.m. that morning, and there's like 20 calls on there, let's say, and one of those is Sowinski, wouldn't that kind of prove that he called that morning, whether or not it was at 5 a.m. or 8 a.m.? He did call that morning to report something.
Yeah, absolutely. Yeah. So that would lead, if that is indeed the case, then, that gives his affidavit more teeth. Now, there are problems with his affidavit. We won't, not even get into all that, but if that is indeed the case, that would definitely give his report a lot more footing.
A lot more validation on it would validate some things for me more so.
Absolutely. Yeah, I agree.
Yeah, but again, would would it change the outcome of the trial? That's what it's going to come down to. And
Well,
I
it could
don't
be
know
another
that any of the
Brady,
calls.
right? Because
What's
if
that?
somebody called there and we know they didn't give all the calls to the defense back then, they just get them now. And there is a call that was Sawinski, and he is saying it was about Teresa Hallbach, and they didn't record it. Isn't that a Brady violation?
Well, even if they
Isn't
did,
that some footing?
I think
her?
everything's recorded. Why is it cut off? That's
Like,
my
why isn't there a copy of it?
You know, although that sounds good, we all know that the whole Sawinski matter is really a lot of bullshit. I would never try to run with Sawinski's story, so I don't know that I would just want to run with a call not having been turned over and use that as a Brady claim when the underlying nature of the call really isn't going to give me anything to win on.
I think
I don't know that I'd.
I think she'd have to have a lot more footing around Sawinski for to me to be comfortable. I don't know about you, Sapper, but
yeah, I mean, because from everything that I've read and know about the Sawinski part of this story, I would not go with it. I would not.
I'm not happy with that either. But
no,
I mean,
I'm not either. It needed more everything for me to be comfortable. In what he said he saw. Seriously.
Yeah.
Okay. All right. Well, we'll see. I guess we'll see, what she does, hopefully sooner rather than later.
please be sooner.
The last thing I wanted to bring up is it really pertains to Phil Mealy and him, the Making a Murder musical. And I think I think that I was a little weird about it simply because I'm not really a musical type person. I love music, don't get me wrong. And it has impacted my life from a young age to this very day. But with that said, I've never went and sat and watched, a lot of musicals. I just haven't. I've seen some, when this idea that, I heard about it through Andy B, and then this interview happened. I think that a lot of us were curious as to, his thought process. I was, and after he explained it and understanding British satire, the whole way of, it's a different way of thinking in many ways than Americans or from any other country. Humor is different in different countries. And people have to understand that. I think that just after talking to Phil, I have a much better feeling about what he's doing than I did before. He explained it very well, I thought. And I think anything that, and he's definitely a firm believer in their innocence, that they were wrongly convicted. He made that very clear. I think that he is going to make this in a way that's both entertaining, capturing, emotional, which, it's music, to grab people's attention that may not necessarily want to sit down and watch 10 or 20 hours of Making a Murder, right?
Yeah.
There was also I saw some comments on Facebook about Stephen Avery, people using Stephen Avery's name and profiting from it, from his name, and so on and so forth. And the fact is that Phil made it very clear that all profits and proceeds from ticket sales will be all profits, not proceeds. All the profits from the musical are going to the Innocence Project of the country that it's made in. And I think that's a really neat way to do it. Hopefully it's going to be something that's becomes popular and draws more attention to the case.
The thing about the festival, the Edinburgh Festival, Jack, is one of the biggest festivals in the UK, and everybody, and I mean everybody from all countries, come to the Edinburgh Festival because you've got films that play, you've got musicals that play, you've got comedians that play, you've got people that are trying to start out on something, like a new up and coming comedian will go to the Edinburgh Fringe Festival because they can get venues, they can sell tickets, merchandise, things like that. So, and it's people from all over the world that come to the festival to get their musicals or their comedy career or their films or whatever up and running. It is a good place to be discovered. And as you says, not everybody will sit down and watch the telly, because some people don't have tellies, they just don't. So they've probably not heard of Making a Murderer. So in my opinion, this is a good way of getting it out to a different class, a different style of people. And as you say, the comedy, because it's a comedian that's writing it, doesn't mean to say that it's all going to be comical, you know.
No, absolutely not. I think you'll make a satire of Kratz and the prosecution team, and probably even some of the police officers. He'll make it satirical and a mockery kind of thing, and that's British humor.
Yeah, exactly. Yeah, exactly, Jack. It's the comedy parts, in my opinion, the comedy parts are going to be the investigation, the way the cops handled it, Ken Kratz, Colburn, stuff like that. He's going to be taking the piss out of their characters. I mean, as he said himself, one of the songs that they've got for Kratz is called The Prize.
Yeah.
So I can just imagine how that's going to come across just with the coming. He's going to have them doing a stupid dance and things like that, you know what I mean? But when it comes to telling the story, it's going to be dignified. It's going to be putting the point across. He's not going to make comical of
Teresa.
Brendan or Stephen.
Or Teresa.
Yeah. This is how I see it.
Yeah.
You ready?
Yep.
A year ago, we did something sort of like the Mammothon, and it was called Keep Talking Till They're Walking. If the guy, keeps singing, okay? He's just doing it in a different way. He is talking about this case. He does believe they're innocent, and it may reach a different audience that Netflix doesn't reach, that may bring more viewers and more support to this case by us keeping talking about it. In this case, singing about it or making a musical about it. This is just his way of talking about it, right? That's how I see this. And I think it's a good thing because it does bring more viewers to this case and how ridiculous it is. I made a comment on one of these Facebook groups about, the man thinks they're innocent. He's well versed in the case. I sat here and listened to his interview. I linked your interview to him, and that's my thing. If it's bringing more people's eyes to the cause, what does it matter how it's done? Like you said, they're not profiting off of it. They are putting the money into an innocent project, which is what helped Stephen Avery get out the first time.
Yeah.
So I don't see this as a bad thing, and I know people will disagree with me that don't believe it is a good thing, but in my view it is. And I made note to make mention of it to the people in those groups that are making kind of like statements about it. It's not to be joked about. It's not.
No.
The thing is this case is a fucking joke. I'm sorry. The evidence in this case is a joke. The conviction is a tragedy,
Yep.
And sometimes when you're dealing with such a tragedy like Brendan Dassey, who was only 16 and disabled, and Stephen Avery being wrongfully convicted twice, you kind of have to laugh so you don't cry sometimes.
You have
because
to.
It is very, very sad.
It's tragic.
I'm for comedy. It may not be the right way for some people to be enlightened about something, but I appreciate comedy. So what he's doing, I would love to see it. I'd love to go out there. I won't be in Scotland to see it. I hope Alice and Disco are able to give us a nice review about it. because
Same.
we don't even
Yeah.
know yet. We haven't even seen it yet. We just know it's out there. So
Correct.
how can
Yeah.
we judge something we have not even seen?
Yeah.
Yeah. Well, I mean, I have asked permission, Jinx, if I can stream it for you guys. But he needs to ask permission. He needs to ask the producers. He needs to ask the actors. I don't think it's gonna happen that way. But as you say, me and Disco are going. We're going together. So we know a
Maybe
lot about the case.
here's my
We'll
thought.
have an
Here's my thought.
interview.
Maybe it should not be streamed. You come on, you give us your review, because if you stream it, less people will go see it. If it's any good and people should see it, they should pay the money because the money's going to a good cause.
Yeah.
Yeah, it's going to the Innocence Project here, and he said that if it gets took up, if he can get somebody that can help get it on the road and travel with a musical, if he ends up going to America, it'll be the Innocence Project in America that the proceeds go to. If he goes to France, it'll be an Innocence Project in France. If he goes to Australia, it'll be the Innocence Project in Australia. So it's not even like he's making any profit himself or anything like that.
No,
you know
that's
what I
just
mean?
they're
Any
just
merchandise or anything
they're
that's
just
there
they're just
is
paying for
going
they're
to
paying
that
for their
Innocence Project. So it's
they're
all
paying for their
good.
they're paying for their costs, paying the these people their salary, and that's it. They don't keep anything else for putting in the piggy bank at all. The rest of it goes to the Innocence Project, and that's a good thing.
Yeah,
And
definitely.
not to mention, it also gives Colburn another lawsuit.
Funny.
He'll have a hard friggin' time because it's completely different laws over here, and it's not as easy.
You know, I used to
I
think,
forgot to ask him what he thought what he thought he would do if he does get sued by Goldman. That was one of the questions I forgot to ask him.
you know, think about this
Well,
case and some of the phone calls that we listened to, and Brendan and or Stephen and his dad would get on the phone. Yeah. That went around on Reddit for a year when they would, you doing okay? Yeah. And then somebody else say, yeah, because it's just the way they talk there. And it's funny. You know, there's a satirical part of that as well. It doesn't get seen.
Yeah.
It doesn't get, but it was. And I'm like Jinx, I have to laugh at this shit something. I have to, right? I just, it's so tragic, man.
Well, I'm going to maybe try and see if I can do an interview with him, you know, because I don't think I'm going to get the permission to be able to stream it. I mean, I think that's out the window. But I could always do an interview with Phil afterwards, you know.
Do it with all the actors. I'd like to hear
Yeah,
the
it has
actors,
sense to me, you know, well, afterwards, if you're hanging about or whatever, we can have a conversation. I was like, yes, that would be brilliant. So
that'd be great.
me and Darkside will be standing at the side of the stage going, come on, we've got timekeeping, we want an interview.
Hey, I see we have Michelle Moore in the live chat. Thanks for dropping by, Michelle. We did have a pretty long discussion about Colburn. That's what I originally talked about. But this other case that I put on there, this other video, I didn't have room to put it in the title. I just want, you only allowed 100 characters in the title for your YouTube video. So, but I wanted to show it. I probably am going to split the rest of that part off after the Colburn stuff and make that a separate thing. So yeah, thanks for coming. And now I have to agree, there's no way that Colburn can win. I just don't see it. Anyway, appreciate you coming by. Yeah, we've been here, we're approaching 4 hours, guys. So I know that I'm getting hungry for some dinner. I'm sure it's like 4 o'clock in the morning for Alice, or we're approaching that, right?
Yeah, 3:10 in the morning.
There you go. So I'm going to wrap this up unless anyone has anything else. Oh, I did want to mention, and I haven't been doing it. Dr. Silkman was always better at this stuff than me. Don't forget about, the Foul Play Library. There's thousands and thousands of documents there, not only on the Avery case, but we don't have all the Colburn documents there, but we've got a lot. the hearing stuff. I'm trying to link to all the hearings that we've done or that are out there are in their own channel on the YouTube playlist. Merchandise store. I know Susan and Zoe still work hard at that. I don't think there's been anything added since last week. I think they maybe a couple of new of the innocence. I think maybe got added. I haven't looked, but I think that's what I think I saw a post on that. Check it out. All profits from that. We don't get anything from that at all. All profits go to Uncuffed Innocence, which supports Daniel and many other cases. So you can check that out. And of course, we try to put on as much materials that we think that people want to hear. We're going to continue to follow the Colburn case. I doubt that we'll ever get to see his deposition. You never know. A lot of times in these cases, depositions remains, those don't get released. But some of this other stuff, I would certainly hope that the judge unseals. I really thought that the 4,000 text messages would have been unsealed by now, but they're still not. And then, of course, this deposition that I really thought the deposition that Brenda Schuler did would be open record, because Ludwig, he don't like to sell anything. He made that clear. He's made that clear several times throughout these hearings, because it's federal. They don't want that stuff sealed. So hopefully we'll be hearing something before long. But there's other cases out there as well that are people have interest in. But we try to keep as much of this focused on where we started, along with some other stuff as we go along. But if there's a case out there, something interesting, like this one I just showed tonight, caught my eye, Loveland, Colorado, let us know. If we have time, we'll do something. If there's interest in doing that. What else we got? I think that's pretty much all I got. Anybody else got closing thoughts? Alice, anything you want to add?
No, just the date for the musical was the 9th of August. So as soon as me and Disco have seen it, we will extensively try and give you the best recap we can. And don't worry if we think that it's not what we thought it was going to be, then we will certainly tell Phil. You just don't have to worry about that. But we'll see how it goes, and if I think how it's going to be, I think it's going to be quite respectful in some terms and funny in others. And that's just the way I think it's going to be. But we'll definitely keep you updated on what's what. Thank you, everyone, for joining us, and thanks, panel.
Excellent. Jinxie, any last words before we take off?
Just thanks for coming and watching the show, and thanks to everybody who attended the rally this weekend. And I just want to remind you to Manitowoc is corrupt, so wake up. And keep watching, keep talking, and let's get them out,
Excellent. Well, we're looking forward to seeing any photos and videos and whatever that Rhonda and Cherie and whoever else wants to participate. We'll try to get that.
You can stay tuned on my channel or on my tweets. I did get some documents at the rally this weekend, so I will be releasing them. Some of them we've seen, some of them we have not. Some of them I don't think there's really much in there, to be honest. I kind of skimmed them. But just so you guys have them, and I also got the juror names from the first case. At least their last names were in there in the last part of it. I didn't get to sit and look at. Basically, when you go into the courthouse, you go in and you get the same website, but on their website, you have all the documents showing there. So cool. I will talk about that soon too. So just stay tuned, keep talking.
Sweet. Sour Cup, you got anything?
No, just thanks to everybody for joining us and the discussion. Stuff about law enforcement I know gets kind of heated at times, but all perspectives are welcome. So just keep that passion no matter which side it falls on. And let's get the boys out.
Absolutely. And we should always strive to meet in the middle and compromise and make it work for everyone. I did want to mention one final thing. There's 26 or 27 Brown County jail calls that we haven't released from the FOIA that I got. I know that they are uploaded, and I know that yours is probably going to release those some point tomorrow. So be prepared for your notification bell to start dinging. It's just, we apologize for that happening, but like I said, I think it's 26 or 27 calls that are in that grouping. Some of them are pretty short. Most of them are their standard, 12, 15-minute call. So anyway, that's coming probably tomorrow, Tuesday. I'll probably put something up on the community page as well so everybody's aware. But that said, if you like what we do, give us a like, hit the subscribe, share, continue to talk. It's been a Foul Play production.